May I make a mention? Urgency is there, my lord. I have a vending unit in the Rongia railway station, my lord. I have been served with a notice for vacation on 13th. So 11, 12 are holidays, my lord. So I pray matter may be visited tomorrow, my lord. Because urgency is there, my lord. Full final termination letter has been served.
Catering policy, what, vending?
Vending,
As per the 2017 thing.
17, we have.
And your period expires when?
Actually, I had a license from 2017 that has expired, but they were receiving the that license fees also, my lord. Now NIT was floated at the time when my
We'll
license.
see, okay, we'll see list. No.
Yes, deeply obliged.
Lordship, in item number 2 and 3, Lordship. Lordship, the record is sought from the AIDC, Lordship. The record is received, Lordship, but when I saw the record, Lordship, verified the record, some documents are missing there, Lordship. Therefore, kindly fix the matter in the next week, Lordship. I will bring on that.
Just give me this item too. What is this matter about?
Lordship, it is a tender matter, Lordship. The award was given, Lordship. The matter stays there, Lordship. Where please, my lord. Stays there.
Okay, that,
Yes,
Jaggi Road,
that,
Jaggi Road
that,
matter.
that matter. Lordship, can it be fixed on 16, Lordship?
16th,
Yes, Lordship.
on the prayer for adjournment made by Mr.
J.K. Goswami.
J.K. Goswami, who submits that he has received the reports and which is not objected to by Mr. L.N. Dihinga, learned counsel for the petitioner. This is the matter on 16th.
Lordship. Lordship. In my lord, interim order, my lord.
Interim order to continue till the next day.
May it please your lordship. Your lordship, the concern of the other side, I beg to mention item 8 of today's list.
Item 8, yes.
May I put them, item may be adjourned for the day.
Why?
So, lordship, there is.
It's a very simple question
Yes,
here.
yes, but there is another partner matter now.
Mr. Counsel, there's only one issue here. Whether the inquiry report was furnished or
Right.
not. That's all.
Only maybe next week because there's.
No, who is for the other side? It's a question of
I'm
fact.
taking the consent.
You're taking the consent.
Consent.
Yeah, that's-
So only 1 week, maybe because there's
Sir.
another matter partner going on.
Such.
Item 2, that partner, that's a.
Why there is right. Adjournment prayer has been made by Mr.
Harshan.
R. Sharma, learned counsel for the petitioner.
Okay.
Full stop. He submits that he has taken the consent of the other side. The only issue to be decided in the present case is as to whether the petitioner was furnished a copy of the inquiry report. Full stop. If it is found that the petitioner had been served a copy of the inquiry report, the petitioner would have no case. Correct?
We'll add also other points.
Okay, don't say that loud. Don't say that. That's okay. List the matter after a week.
Obliged, sir. Lordship, may I pray for listing of an item for admission, lordship.
When?
13, lordship, 13.
Okay.
Much of.
May it please your lordship, I beg to mention for listing of a read petition lordship for withdrawal.
Tomorrow.
Meet with your lordship. My lord, the petitioner is your lordship. Is a under cooperative society of 100% actual petition.
When it is order dated 9/4/24,
My lord,
it's not part of the writ petition.
yes, my lord, in fact, the copy we could not obtain at the time of filing. My lord, may I conduct a copy? In fact, my lord, that was a sequel to your lordship judgment, where, my lord, in a particular case, your lordship directed that the fresh tender should be issued. But then, my lord, because of the COVID-19, sorry, my lord, because of the my lord, election, my lord, they could not do it, and therefore it was given on the daily basis settlement. That was the subject matter of that rate petition, my lord, 1911 of 2024. Your lordship may kindly come to the paragraph 2. That was your lordship judgment direction. last paragraph of the last sentence of paragraph 2. However, the connected WBC was allowed by setting aside the order that is so and so. Let's put it further order.
in this order,
My lord,
paragraph 2,
paragraph 2, my lord.
accordingly.
No, my lord, paragraph 2. My lord, next page, your lordship will find, however,
However, yes.
yes, however, the connected WBC 8281 was allowed by the setting aside the order dated 23/12/2029 issued by the Deputy Secretary Government of Assam Fishery Department. It will be mentioned that by order dated so and so, the respondent authorities have allowed Messrs. Chandrakala Bill Fishery Cooperative Society to operate the fishery on daily basis. This court further had ordered that keeping in view the fact that the interest of public acquisition would be best served if a new tender notice is issued by the state, the respondents, and the fresh settlement of the fishery is made, which should be commensurate with the prevailing market rates. Accordingly, the state rules were given liberty to initiate a fresh tender notice for settlement of fishery. Then, my lord, because of the, my lord, election guidelines and the time it will take, the fishery was settled with that petitioner on day-to-day basis till final settlement, regular settlement, and that was under challenge in this order. And in this order, well, this is an interim order. If your lordship kindly comes to paragraph 16. Paragraph 16 at my lord, page 13.
Yes.
It is further provided that in the event the tender process cannot be completed, what happened, my lord? In view of the, in spite of the election code of conduct, my lord, the court directed that it has put it, my lord, the guideline, and said that it can be advertised even during the election conduct, the rules, which is not correct, my lord, and the appeal has been preferred, that is pending. Now, it is provided that in the event the tender process cannot be completed within 10/5/2024 in respect of that fishery, in that event, if ad hoc arrangement of daily settlement is made, the respondents, especially the Commissioner and Secretary Government of Assam Department, shall, in respect of the present fishery in question, issue a guideline to be followed for having a daily settlement of fishery in question. Thereafter, the respondent number 1 and 2 shall also either have the Rule 12 of the Assam Fishery Rules 1953 amended, or to issue a guideline for the entire state of Assam in respect of all the fisheries covered by the Assam Fishery Rules 1953. Then your lordship can come to paragraph 18. Paragraph 17 also, my lord, if for any compelling reason daily settlement has to be extended beyond 10/5/2024, the process of putting the tender on daily basis shall be notified in Dhubri district, so as enable all the fishery cooperative societies in the said area to participate in the process. In the event the tendering process is not initiated or cannot be brought to its logical conclusion within 1 month from 10/5/2024, on and from 10/6/2024, there would be no daily settlement and the fishing activity in the present fishery on ad hoc basis. So, my lord, all these directions, this is an interim order, all these directions were with respect to that particular fishery in Dhubri district. Now, your lordship, it kindly comes to the present petition at page 24, which is the order in June.
Yes.
Page 24.
Yes.
Peruse the order of the Honorable High Court dated 9/4/2024 in WBC 1911 that your lordship has just read, my lord. Then the letter dated so and so from the Standing Council. It appears from the above that the system of running 60% government fisheries on daily basis in the interim till next regular settlement has been reviewed by the Honorable High Court in the instant writ petition and was of the view that such arrangements are not commensurate with Rule 12 of the Assam Fishery Rules 1953 as amended. Such arrangement often leads to litigation as rival parties also stake claim on such arrangement.
No, you see, Rule 12 provides for tender process.
Yes, my lord.
Then
Rules are, my lord, silent. There is nothing in the rules that, my lord, the day-to-day settlement can be given.
no. So there's nothing that,
There is nothing. Now, what happens, my lord? Because of many factors, the authorities are not in a position to give regular settlement. For instance, my lord, in the instant case, what happens, my lord, there was a dispute regarding.
but what is your right to have the daily settlement?
My lord, daily settlement has been given, and that is also in the interest of revenue of the state, my lord.
No,
My
no,
lord, this your lordship will look into it from the point of view of, my lord, the cooperative societies.
at best we can
Cooperative.
issue notice, that's all. Nothing more.
Now, my lord, what I am trying to impress upon your lordship is that the observation that was made in the order, my early order, your lordship is there. That was, my lord, confined to one particular fishery in Dhubri district. Now they have, my lord, interpreted it as if, my lord, this is for all the fisheries all over the state of Assam.
But what is wrong? If it's a policy decision, what is wrong? Is it against the rules?
No, it's not a policy decision as such, my lord, because they say that this is
No,
pursuant.
but what is the arbitrariness? What is your right to continue having a daily settlement of the fishery on a
My
daily
lord,
basis? Where
that's
is
why,
your
my
right?
lord, I'm, my lord, imploring your lordship to look into the matter from the view of the, my lord, cooperative movement. Why, my lord?
No, cooperative movement, you see, all these cooperatives can participate in the tender process. It's not that you're not allowed to participate. Why should you be given undue benefit vis-a-vis the other cooperatives that are there in existence?
My daily basis settlement has not been questioned by anyone, my lord.
They're taking a decision not to give it on
Not only,
by way of a tender
not only
process.
mine, my lord, all over the state of Assam, they are,
Correct.
my lord, tomorrow, they'll be taking over all the, my lord. My lord, what purpose would it serve? Your worship will see. The purpose was, my lord, is to, my lord, encourage the 100% actual fishermen, my lord. Number one. Number two, in the interest of the state, revenue of the state.
Let us see what section 12 says. What does it say? Section 12.
It is, my lord, the settlement,
Through tender process.
through tender process.
Then even if it's a daily settlement, let it be through a let it be through a tender process.
That
What is
can-
wrong?
Yes, my lord, that can also be directed. That can also be
So
directed.
now that means every day you're going to have a tender. Is that practical?
No, my lord, the daily settlement,
You see,
they fix a rate, my lord. On that basis, till the regular, because, my lord, this is only ad hoc arrangement till the regular settlement is made. And it is not the case of the, my lord, authorities also, that, my lord, daily settlement, that is, my
no,
lord,
you see, maybe it is to prevent the some persons from getting unduly rich due to settlement of a fishery on a day-to-day basis. Today it'll be 2 rupees, tomorrow it'll be 3 rupees, day after tomorrow it'll be 250, then again 2 rupees. So it might change, the
Why
rates
not?
might change day to day.
but this is only a stopgap arrangement till
Maybe.
the regular. And,
But
my
this,
lord,
but this stopgap arrangement I've seen, some of them have been going on for years.
some of them, yes, my lord.
Let-
Yes, my lord, and
So
there are, my
that-
lord, cogent reasons. Why, my lord,
So this issue cannot, I don't think there's any ground for stay. As of now, you have completed your term.
No, my lord.
Well,
My lord, there was a
were
direction.
you settled with the fishery, with this fishery?
My lord, there was a direction from this honorable court that, my lord, it should be, my lord, the tender should be invited. But the authorities could not do it because there was dispute regarding, my lord, the area of two adjacent fisheries.
Hmm.
Therefore, my lord, unless they can settle the dispute, they, my lord, cannot, my lord, settle it on regular
Then
basis.
how are they settling it on a daily basis with you? If they cannot do it on a long-term basis, why should they do it on a daily basis?
My lord, that
When
will-
the
that will
dispute
only, my lord.
exists, the dispute will, is it, if it's existing as on date,
Right.
why
Yes.
why are they settling on a daily basis, even though there is a
My
dispute?
lord, your lordship will kindly see the order of daily settlement that was given to me, my lord. That has given some kind of semblance of right to me, my lord. That order, your
No
lordship.
right, you've got only a right for the day. No right beyond that particular day.
No, day-to-day basis, my lord.
That's what I'm saying. It's per day, it's
Your
not for a
lordship will
year.
kindly
or
see
a
the
month.
reason. But, my
Let
lord,
us-
reasons have been given.
Let us see.
That order, your lordship will find at page 21.
Yes.
My lord, I cannot have any objection if for day-to-day basis settlement also, my lord, they issue tender. Because this is a situation, my lord, particular case, all cases are not, my lord, similar. Here, my lord, they can give it because they could not till now, my lord. They have not been able, my lord, able to settle the dispute. Your lordship will kindly see the order at page 21.
Yes.
the order of the National Green Tribunal, because my lord, the matter went to Green Tribunal because of the fact that my lord, Dibru-Saikhowa National Park and Dibru-Saikhowa Biosphere Reserve, those are also, my lord, came into that fishery.
That is what, if it is all, if it's a reserved forest or reserved area, why should there be any fishing at all in the first place?
No, my lord, your lordship will see that has been settled. In the meantime, that has been settled by the Green Tribunal. That your lordship will come to, my lord, paragraph 2.
Hmm?
The state fishery was earlier run by so and so on daily basis by government fish, the order dated 9/5/2007 on rejection of claim of regular leasing for further extension. However, the Honorable High Court by order dated 3/8/17 in WPC so and so allowed the temporary lease up to 30/9/2017, directed government respondent to settle the fishery through tender system with demarcation of boundary. So, my lord, that was necessary, excluding the areas falling within.
So 2017 order
Yes.
is for settlement of the fishery uh, with demarcation of the boundary. Now from 2017 till date, they have not settled the boundary.
My lord, sir, they have not been able to.
But in the meantime, you are allowed daily fishing. Why should you be allowed?
On 440 rupees.
On 440 rupees. Huh? 440 rupees per day.
Per day.
That comes to how much per year?
One fish day. One fish cost, I think.
One fish, it depends
One
upon the size of the fish.
No,
The last time I bought for
my lord-
700 rupees per kg.
My
Only
lord,
the
if-
head I'll get.
No, my lord, if for that reason, my lord, that the amount is very low, on that ground it is rejected, my lord, there is no question. of
No,
that.
Mr. Chaudhary, nothing. I'll issue notice if you want.
lord-
Otherwise, I will find no case.
Okay. There is, can you go to this order? Give you pardon. There is a pending, there is a case pending.
And that's the most I can do.
My lord, they are to, my lord, explain why they have not been able to do it.
That's why I'm going to issue notice. Let them explain.
In the meantime, my lord, what is the point in, my lord, losing revenue by the government?
What revenue? You give me your catch per day, I'll give you 440.
I am also ready.
You also ready, everyone is ready. In fact, we'll go and open a shop in Ujjan Bazaar or something like that.
But it's a very small area, my lord.
Small area. How many members are there?
We have got 67.
60,
68.
68. You're not even one fish per person. How are you going to divide the profits? Forget about your costs.
No, my lord, the
Expenses.
question here is, my lord, I have been given a settlement till, my lord, the final settlement, regular settlement. They are not in a position to settle it. And what is the harm in my?
That is what, if they're not in a position to settle it on a year-to-year basis or on a monthly basis, why should they settle it on a daily basis? Whether it's for a year, a month, or a day, the problem still remains.
Problem remains.
Then-
The question here is, my lord, you had given me a settlement. You are taking away.
Not through a
taking it
tender
away.
process, not through a tender process.
But then, my lord,
It is-
am I
it is-
am I not entitled to a notice, my lord?
Huh?
A right has accrued by this order.
No, you have come. You have come here. You have got no right. It's not to settle.
My
the-
right flows from this order, my lord. They have justified why there has. to
It
be,
is
my lord.
against Rule 12. It is against the law, statutory law. Where is your right?
Now, if your lordship kindly sees my lord, the broader picture, they will be losing revenue in all the, my lord, many of that, my lord, those.
That is their lookout. We will cross that bridge
No, no,
once.
that is
once-
high-handed, my
once
lord.
we
That
get
is
to that bridge.
That is unreasonable, my lord. That is unreasonable. They have to act in the interest of the state.
I'm sorry this time. Unfortunately, no. I only noticed, that's all. Like I said, you give me every day, I'll give you that 440 myself. In fact, I'll give you 500 rupees.
My lord, at least let they feel that they get the, let them.
No. This will have a rippling effect in all the other cases. It'll have a cascade. Tomorrow you'll come up with 10 more cases. You say, yesterday similar order, please give similar order.
My lord, that is a boon for the lawyers. also.
You have got to keep that in mind also.
That is also knowledge, your lord.
This is, I'm quite sure you have got in your kitty another 10, 12 cases just ready to be filed.
This notice was, this order was selling in the Rich Court Lordship. This is a part of the report also. Giving them that.
Whatever it is,
The question here is, my lord, whether the order passed in the earlier case that has been rightly interpreted. my lord. That was-
no, I know, you see, there are many aspects, there are many ways of looking at this. Now we are looking at it the way you want us to look at it.
I am trying to, my lord, persuade your lordship.
Yes, I
that
know.
my lord-
But then now, we have also got maybe our views on this, which we do not want to say everything, depending on what comes out from the other side. But per se, right now, I don't think this is a case of stay. I can understand if you had been given the settlement through tender process, some right had accrued to you. 2017, now it's
No,
24.
it's 2019, my lord.
19, anyway, 24. Daily basis, since 19, doesn't seem proper.
In 440 rupees that also.
Huh?
In 440 rupees.
440 rupees per day,
Let them.
For- huh?
440 rupees per day.
Per day.
Ah.
And 60% are in their society. And 100% fishermen probably,
My lord.
100% fishermen giving 440 rupees, probably earning how much? We do not know. He'll be saying, I don't know, maybe 1,000
My
rupees
lord,
or
that figure was, my lord, determined by them, not me, my lord.
whatever.
They can now.
So you can imagine if there is competition, bidding between different societies.
Let that be there, my lord. Let that.
Let them be there, correct? But then what you are saying now in your petition is there cannot be a settlement because there is a dispute regarding
I
the
say, my
boundary.
lord, they are not able to do the settlement, my lord.
Anyway,
What I say, my lord,
let them give their answer. We'll settle it once and for all.
We'll tackle it, lordship.
Okay, right. Heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. Huh? D. Kalita, Learned Counsel for the petition. D. Kalita, huh? Who submits that the petitioner society is aggrieved by the action of the respondent authorities in issuing the impugned order dated 12/4/2024, directing the district commissioners to take over possession of 60% fisheries which are run on daily basis / temporary basis. First up, the senior counsel submits that the petitioner society comprising of 60 fishermen,
68, my lord.
68 fishermen has been running the Dibru Brahmaputra fishery, Dibrugarh district, since 2019 on a daily basis.
At a revenue. fee-
Till regular settlement is made. First up, he submits that as there is a dispute with regard to the
Area.
demarcation / area with another fishery, namely Brahmaputra Part 3, Roman 3, yeah, comma 4, Roman 4 and 5 fishery of Dibrugarh district, comma. The respondents have not been able to settle the fishery on a regular basis. He submits that till a regular settlement is made, he should be allowed to, the petitioner society should be allowed to run the fishery on a daily basis. First up.
My further submission is that, my lord, this is in wrong interpretation of the order caused by this honorable court.
First up, he further submits that the impugned order dated 12/4/2024 has been issued by wrongly interpreting the order dated 19/4/2024.
9/4/2020.
Huh?
9/4.
19.
No, my lord.
19/4/2024.
19 is a pending case. They have a pending case. They
That
have
is
not-
another.
Passed in WPC number 3459 of 2023.
The order passed in this case,
Acha.
not your lordship's order. my
Okay,
lord.
okay. huh.
Actually, this.
Passed in 9/4/24 in WPC number 1911/2024.
Actually, this case, several cases is pending, lordship. That is in arising.
19/11, you have not given me this order.
One and I just given to you.
1911.
Your lordship has just great.
Acha, it's here, yes. Next para. Issue notice returnable in 4 weeks.
My lord, let it be shorter.
Okay, let it returnable in 3 weeks. Mr. P. Sharma accepts notice on behalf of.
On
No.
the deputy commissioner.
1 and 2. Correct?
Yes, Lordship, 1 and 2.
And Mr. M. Chetia, except notice on behalf of point number 3. Full stop. Mr. P. Sharma submits that the petitioner has been given, is giving rupees 440 as revenue for giving the daily settlement rights over the fishery.
It is in the petition also, order, Chair Lordship, page number 22, Lordship.
Anyway, he submits that the above clearly goes to show that the state government is making a huge loss. As 60% are are giving only 440 per day. 68 fishermen are giving only 440 rupees per day for fishing rights on a daily basis. Good, sir. Rule 12 of the Assam Fishery Rules 1953 provides as follows, huh? It is here. Now, provides that the tender system is to be followed for settlement, for regular settlement of a fishery. Gustav. Rule 12 of the Assam Fishery Rules, 953 is quoted below as follows. Huh? This is a matter on
Along with that matter, Lordship, there is a pending matter also, Lordship.
which one?
And this Libru,
And this is matter
yeah,
after 3 weeks, 3 weeks, I think,
along with,
along with WPC 3459 of 2023.
several cases are pending. Lordship, I pray Lordship, here, Lordship, kindly do not record my statement that there is a loss of the government, Lordship. Actually,
Okay, that will be my finding.
Because they will be losing that amount also.
Huh?
If Lordship says my finding,
Now,
Lordship.
my lord, may I pray that my lord, the taking over will be subject to further orders that may come by this.
That is always there.
No, Lordship, it will give a.
No, correct.
Oblige, Lordship.
I think one for everything.
Lordship, may we pass over for the time being. Please in court number 1, we will immediately.
Lordship, I can start my argument, but take some time, you can come and join in.
We don't know when he will come. That's the problem. Just wait.
Lordship.
I think four.
Maybe
Five BTC have filed a certificate, my lord.
Huh?
on
I have
six,
filed my
my lord,
affidavit for BTC.
on 6 they have filed, my lord, we will file reply, my lord, within 10 days.
Okay. Mr. S. Bora, learned counsel for the BTC, submits that affidavit in the position has been filed
Both the cases.
in in file. Then Mr.
K.S.R. Ahmed.
A. Jalan.
K.S.R. Ahmed.
H.R. Ahmed, learned counsel for the petitioners is granted. How much time?
2 weeks, my lord.
Granted 2 weeks time to file affidavit in reply.
There is-
What about you?
I am,
Are you filing anything?
I will adopt. With file by that.
Are you filing anything?
No, I am not.
Okay, Mr.
Yeah.
J. Ahmed, learned counsel for the respondent number 10 submits that the respondent number 10 will not be filing any affidavit.
I will file.
Huh?
I will file, they will file, I got the copy, my lord, I will file within.
Okay, you will file. Submits that he will,
Within 1 week, I will.
submits that he will file affidavit in opposition within 1 week. And list the matter after 2 weeks. Interim order to continue till the next day.
Lordship, fix a date.
Because there is an interim order.
Mm.
My lord, obliged.
Five also same, yeah, 10, yeah, number 10 there also. One thing also you write, huh? Registry to place the affidavit of the state respondents on record. In both, huh? Same order.
May I please your lordship? My lord, the petitioner is aggrieved by the manner in which the assessment bill has been prepared by the respondent APDC. Lordship will kindly see the first.
So you are not filing any affidavit in
I am
reply.
not fine.
Then why do you take time to file? Last time also you.
No,
decided
last
to
time
file.
I took time because the day before I was served a copy of the affidavit in opposition. So I thought that a reply may be required. So since the time was very short, I could not go through that. So that is why I prayed for time.
That is why I did not read your file. I thought the affidavit reply. Anyway, we'll do it. What is that?
Lordship will kindly see the first order dated 2/11/2017. May I read it, Lordship?
Yes, yes.
The petitioner is a tea company which manufactures black tea in their factory at Marongi in Golaghat district. The Assam Power Distribution Corporation Limited has sanctioned 620 kilowatt load and installed meter number so and so in the factory for the purpose of billing. However, meter tampering was detected during the date of inspection made on 9/1/2016, and accordingly revised assessment for preceding 12 months was made on the basis of the connected load, and doubling the assessed sum, rupees 1,50,09,966, was raised as electricity bill. The consumer deposited 75,000
25 lakhs.
4,983 during the assessment process, and thereafter consumer approached the appellate authority against the assessment order. In the appeal number so and so under order dated 26/7/2017, the appellate authority noted the meter tampering and held that assessment bill served for the area manager IRC at Jorhat on 25/2016 is justified. However, 20% waiver of the penalty for early payment of the assessment bill was granted to the consumer. Placing reliance on section 126(5) and 6 of the Electricity Act 2003, the consumer applied for review of the appellate order with the contention that computation should not be made under the AIFC supply code, but should be done as per section 126(5) of the Electricity Act. However, the authority ignored the issue of computation under section 126(5) and instead referred to the peak and the off-season from December to March. The off-season in the tea industry, and granted them 40% waiver of the assessed sum for the off-season from December to March. However, the waiver of penalty ordered earlier was withdrawn under the impugned order dated 19/9/2017. Assailing the computation process for the consumer found to have indulged in malpractice, Mr. So-and-so learned senior counsel submits the subsection 5 of section 126 of the Electricity Act was substituted by Act 26 of 2007 with effect from 15/6/2007. Whereas the ARC supply code was notified 2 days earlier on 13/6/2007. The council therefore submits that assessment must be made under the Electricity Act, and anything contrary to the contrary contained in the ARC supply code must not override the statute. However, whenever unauthorized use of electricity is detected, the first attempt must be to ascertain the amount payable for the consumption. But if the same cannot be verified, the computation should be limited to a period of 12 months immediately preceding the date of inspection. The bone of contention in the present case is how the amount should be assessed for the preceding 12 months.
The petitioner in paragraph 21 has projected that they were assessed to electricity charges to the tune of rupees 42,26,618 during the 12 months of 2015. And therefore, doubling this sum under section 126(5) of the Electricity Act, the liability for the malpractice is quantified by the consumer at rupees 84,53,236. However, the area manager IRCA has assessed the payable sum for the preceding 12 months on the basis of the connected load of 620 kilowatts, and on that basis, the final assessment of 1,50,09,966 was determined. But after the review order, without accounting for the off-season, in the tea industry, the total figure is assessed at rupees 1,09,19,712. Just subtracting the already paid sum of rupees 75,04,983. The assessment bill dated 3/10/2017 for rupees 34,14,729 is now raised against the consumer. The computation of dues for unauthorized consumption of electricity is required to be made in terms of section 126(5) and 6 of the Electricity Act, as has been held in Southern Electricity Supply Company of Orissa Limited versus Sri Sitaram Rice Mill, reported in 2012 to SCC 108. A division bench of the Kerala High Court in so-and-so versus so-and-so, interpreting the provisions of section 126, substituted with effect from 15/6/2007, had declared that whenever a consumer commits breach, they are liable to pay at a rate equal to twice the tariff to be assessed in terms of section 126 of the Electricity Act. Similar view is also taken by the Calcutta High Court in so-and-so versus so-and-so, reported in KR 2010, Calcutta 84. In the present matter, there is no dispute between the consumer and the APDCL that in case of malpractice, the assessment of tariff is to be made with reference to the 12 months preceding the date of inspection. The issue here is whether the charges are to be calculated on the basis of power bills in the preceding 12 months or on the basis of sanctioned load, as is claimed by the APDCL. If sanctioned load is made the basis, the off-season low consumption in the tea industry, as has been recognized by the appellate authority in the review case, as has been recognized by the appellate authority in review case, will be ignored or something. Therefore,
If
the
sanction load is made the basis, the off-season low consumption in the tea industry, as has been recognized by the appellate authority in the review case, will be.
review case is ignored, then what is in between will be ignored.
Will be, must be.
Yes, must be, will be ignored. Therefore, the computation made by the
No, what
APDCL.
does it mean out here? If sanction load is made the basis, the off-season low consumption in the tea industry, as has been recognized by the appellate authority in the review case, will be noted. What is this? I don't
That means
understand
the off-season consumption is less. So that consideration will not be taken into account.
this. No, but what is, if it is as per the sanction load,
Yes.
then there's no question of the actual electricity use is not the criteria. Sanction load is a sanction load. Sanction load will remain the same, I think.
No, even though the sanction load is high, because in the off-season period, the entire amount of sanction load is
Will
not
be lowered by how much?
40%,
40%.
as has been stated.
Okay, so okay, if sanction load is made the basis, so this is wrong. How can the off-season low consumption be? How can it be ignored? If say 100
Is
kilowatt
the sanction
is
load.
the sanction load.
Yes.
Now, if you are going to have the calculation made as per the sanction load, 100 will be there. And for the off season, it will be 60.
60.
But this portion of the order says, if sanction load is made the basis, the off-season low consumption in the consumption will be ignored.
Yes.
Consumption will be ignored.
Therefore,
So it will be only on the basis of the sanction load,
sanction load.
or whether it's going to be on the basis of consumption.
So my case is that since for the preceding 12 months, we have been billed 42 lakhs and odd. So as per section 126, 5 and 6, we have to pay twice the amount. So that is what our prayer before the FPDCL authority was. But they have calculated the assessment bill on the basis of the sanction load in a different manner. So
So you are saying that you should be billed twice the consumption use.
yes, that is my, and Lordship will kindly see the assessment bill then.
Let's tell me. Assessment bill, yes.
Yes.
Page,
I think that is annexure 6.
First one.
huh?
No. No, then you have changed it as the first one.
First one.
That is annexure. That is annexure 4, Lordship,
Page,
46.
yeah,
This is to the petitioner, Sanjeev Tea Industry.
yes,
The compensation bill amounting to rupees 1 crore 50 lakhs 9,966. Right, bill number so and so dated 11/1/2016 is served upon you, which has been assessed on the basis of clauses 5.A.3 and 5.A.4 of terms and conditions of regulations notified by AERC. Evidence revealed that you are directly or indirectly involved in the act of malpractice for which service connection was disconnected on so and so. 9/1/16. A statement of the assessment bill is enclosed herewith. Unless the amount of the assessment bill with the reconnection charges are received, the service connection shall not be reconnected. So accordingly, we paid 50% of it. The bill is next noted, annexure 5 at page 47.
yes.
And accordingly, we paid 50% of it, that is 75 lakhs and odd, and our electricity was reconnected.
Where does it show that they have paid 50%?
That is not disputed, Lord.
Okay.
That is an admitted amount.
So that 1.5 lakh that has been calculated,
Yes.
it is on the basis of consumption.
Consumption. So my case is that as per section 126(6), since malpractice has been established, I am not disputing that. So I have to pay twice them. So initially for last preceding 12 months, I have paid 42 lakhs and odd, and I will have to pay 42 lakhs and odd more. That is 84 lakhs and something. So I have already paid 74 lakhs, 75 lakhs. And that apart, I had earlier paid 42 lakhs. That was the consumption. I mean, the bill raised for the
But
consumption.
the bill raise is 1.5 lakh,
No,
not 80,
no,
1.5 crore.
no, I'm not on that. What I am trying to say is that since for the preceding 12 months, I have already paid 42 lakhs and all. Because they had billed me and I had paid. Then they have detected the malpractice. So on detection of the malpractice, I will have to pay twice the amount. So I'll have to pay 42 lakhs and odd more. That means 84 lakhs and something. Then I have, and out of that, I have already
No,
paid
the first before malpractice, you were found to have what? The bill was for what?
The bill as raised by them, Lordship, I have made a statement, Lordship will kindly
So
see.
at the time of malpractice,
Hmm.
your bill for 12 months was 40?
42, I am giving the exact figure, Lordship. 42 lakhs, 26,618.
Ah. So because of this malpractice,
Yes,
under section 125,
126,
126,
6.
under section 126(6),
Yes,
you are supposed to pay double the amount,
double them.
double the amount. And you have paid 42 lakhs also,
Yes, so I'll have to pay this
another
amount
40
again.
again, according to you.
Yes. So in order to get the reconnection, I have already paid 75 lakhs and all. Otherwise, my connection would not have been restored. And that apart, Lordship, as per this
So why
order,
did they charge you? Why did they charge you 1.5 crores?
the Lordship, that is what they have informed me. I have shown an extra. That
They
is,
have said that as per clause 5.8.3 and 5.8.4.
yes,
What is this clause?
these are clauses of the supply code. Supply code.
So this is the supply code which was enforced there.
Enforced at that time. So there was no 125 or 126.6.
Perhaps what I have understood the case the petitioner is trying to make is that after an inspection, my learned friend will correct me if I'm wrong. After an inspection in his premises, it was established that there was a foreign circuit inside his meter. Accordingly, provisional assessment was done, final assessment was done. Matter went before the appellate authority. Appellate authority reduced it, in fact, saying that since it's a seasonal company, it should be reduced. There were some concessions were granted by the appellate authority. They filed a review before the appellate authority against that order. Some further concessions were granted to them. The case they are trying to make out here, Your Lordship, is that under section 126, the amount when a person indulges in unauthorized use of electricity, the amount of electricity charges payable is to be assessed at twice the tariff, not twice the amount, twice the tariff payable for that category of services for 12 months of the period, if the exact period
What do
cannot.
you mean by tariff?
Tariff is the rate per unit, Your Lordship.
So as per the electricity consumed,
And as the amount of electricity consumed will be as per the best judgment assessment of the assessing office. So there are three components. One is the tariff, one is the consumption of unit consumption.
what is the, just a minute, tariff?
To calculate the charges, one is the tariff, one is the time period, which is it is said if the exact period cannot be ascertained, it will be taken as 12 months. And the third is the actual electricity consumed, which will be as per the best judgment assessment of the assessing officer. Now, Your Lordship, to give certain parameters to the assessing officer to make that best judgment assessment, the AERC has framed the supply code. This is the code which Your Lordship has. As per that code, a specific formula is given under clause 5.8.4 as to how, because if a foreign circuit is inserted in a meter, we cannot ascertain what was the actual consumption of that meter. That is impossible because if it is 100, it might show 20. So a formula is given. So this is the formula as per which the units has to be calculated. And on that basis, this assessment,
Show me the regulation.
the regulation Your Lordship has here,
Yeah,
there it will be clause 5.8.4.4 at page 1222. Bottom of the page, Your Lordship.
Yes.
Unmetered use of electricity, theft of electricity. When a consumer indulges in theft of electricity, the officer authorized in his behalf by the government of Assam may, without prejudice to its other rights, assess the quantum of electricity loss on the basis of the assessed consumption of detected category as per table under 6.2.1.1 and connected load for a period of 6 months prior to the date of detection and will be billed at the rate of 1.5 times of the existing tariff. Just one thing here I'd like to clarify. This 6 months and 1.5 times, your lordship, later the Electricity Act was amended and it was made 12 months and 2 times. So this act was also, I have the amendment here. The amendment says it will be 12 months and 2 times now. This is the amendment. So it is in terms of section 126, but the formula at which your lordship will find.
Just a minute.
Lordship. So 12 months and
Yes,
2 times is taken care of. What remains is the third component, which is the best judgment assessment. How that is to be done, your lordship, it is to be done as per the schedule at 6.2.1.1. That your lordship will find at page 1225.
yes.
So your lordship, there is a schedule there. So this is I believe they are an HT2 category consumer. So the
Are you HC2 category consumer?
Lordship, my connected load is 620 kilowatt. So,
I'm not on that.
yeah, no,
As
so
per 6.2.1 of the code, under which category of consumer do you belong to?
Lordship, that I cannot say with precision. So thing is that if I'm 620,
Okay, so we'll have to accept his.
yes, we'll have.
So
So according
This-
to you, we are H2, HC2.
yes, now what the petitioner is claiming, your lordship, if I may take your lordship to the Electricity Act, that will. My learned friend will correct me if, but this is this claim. He found this is the case made out in the petition. Section 5, if your lordship has of section subsection 5 of section 126. Five and 6. If the assessing officer reaches to the conclusion that the unauthorized use of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period will be limited to a period of 12 months immediately preceding the date of inspection. Then next, 6 says, the assessment under the section shall be made at the rate equal to twice the tariff applicable to the relevant category of services specified in subsection 5. So twice the tariff means twice the tariff fixed for that category of services. He is saying that since the last 12 months, his bill was say X, or he's saying 40 odd lakhs. So he's going to pay twice that. Now, this is a case of a tampered meter, lordship. Though it might be saying 40, it might be 3 times, 4 times more than that. We have no way of ascertaining. So that is why this formula has been given in the supply code, that
In the Electricity Act.
Electricity Act read with the supply code, which is framed under the Electricity Act. Now, unless this code is declared to be ultra virus by a competent court of law, this code will apply, your lordship. He wants section 126 to override the provisions of the act, of the code, without there being a declaration. And in this petition also, he is not prayed for a declaration that the code should be declared ultra virus. He just wants that the act should be applied. And perhaps even if the act is applied, it will be against him. My interpretation of the act may not be.
This Electricity Act, so what does it say basically? It says that such period shall be limited to a period What do you mean by tariff? Let us see what is the definition of tariff?
Definition of tariff, yes, Your Lordship, that perhaps.
There's no
There
definition
is
of
no
tariff.
definition of tariff.
The assessment under this section shall be made at a rate equal to twice the tariff applicable.
Why is the tariff applicable to that category of services?
So what do you mean by tariff? Do you mean, does tariff mean the actual consumption or what? What does it
Tariff,
mean?
Your Lordship, would mean the rate tariff which is fixed per unit charge of that category of
Okay,
service.
the tariff, the
Yes.
rate.
That is the rate, because it. Now, in fact, in this case,
The period. Where does it say that it shall be on the basis of the sanction load? Your case is that it should be on the basis of the sanction load, correct?
No, no.
Then,
My case is that it will be. I
Why
have
is-
to, since malpractice has been found, I will have to pay twice the amount which I have paid earlier. So earlier I have paid 42 lakhs and odd. So I'll pay more.
so
42 lakhs twice.
so what is wrong with this submission?
because, Your Lordship, the calculation which was done, in fact, calculation was done as per the formula given in clause 5.8.4.4.
Acha,
Now he wants section 126, even if it is done as per 126, it is the same formula.
that's right.
His interpretation of subsection 5 and 6 is not tariff, not as the unit charge, but the actual amount he has paid over that 12-year period,
12-month period.
12-month period.
Oh,
I will
the
pay-
actual period. okay,
Actual amount paid in the preceding 12 months when the meter was tampered.
It cannot be.
So your lordship will kindly see the reasoning. Since,
I understand.
yeah, since the.
No, you see, no, but but the issue is, the bill had come to 1.5 crores by you.
1.5,
Now he says that it should be 80 lakhs.
84.
42 into 2. Yes.
Yeah, 85 lakhs or whatever. Now, how did you come to that 1.5?
That statement of assessment is at page number 48, Your Lordship.
And how did you come to 42?
Because
Because
it
of the
it
bills
will
paid
be-
for the last 12 months.
Twice the amount
Ah.
which I have paid in the previous 12 months. The previous 12
Okay.
months, I paid 42 lakhs and odd. So I'll pay it, I mean, once more.
What we have applied the formula as given under the supply code. It is
And-
discernible from page number 48 of the petition.
And this supply code, my learned friend will correct me, was made prior to the amendment of the Electricity Act. This 126(6) came to be applied from 15(6).
No. 6 existed, only there was one change, Your Lordship. Earlier, I have the unamended Electricity Act also. The only change was earlier, it was 1.5 times, it has been made 2 times. 6 existed. This is the unamended, I've just got the relevant portions, Your Lordship.
Oh, fine, somewhere.
The unamended Electricity Act, 5 and 6 existed. But earlier in 5, it was for a maximum period of 6 months. And the maximum assessment was to be made at 1.5 times the tariff applicable. That 1.5 times has been made 2 and 6 months has been made 12.
You know, in a very simple way of looking at it, he's correct also. How do you come to this 1.5? Let me see the
Yes,
calculation.
the calculation is at page number 48, Your Lordship.
Assessed consumption for 12 months.
12 months. We have assessed it at 620 kilowatt is his category
Huh.
as per the chart.
Hmm.
200 units into 12 months. 12 months is the period, your lordship.
But this is the sanction load,
SS
622
Yes.
kilowatt.
Yes. So this actual units built was
Actual units is 200 units.
the actual
what?
units is 348. No, the actual units built was 348,326 units.
Ah,
The SS units is 620 into 12 into 2. So that is 148800. And the loss we have subtracted the SS from the actual units built. That is the loss 1103674. And the charge is 1103674 into 2 into 6.75. That is the tariff.
What is this 200 units?
200 is your monthly consumption
Average.
average.
620, this is the way it's calculated.
This is
over.
the way it is calculated. And he's saying it should be as per. He's saying that this should be what the actual amount billed for the past 12 months. That is the, in the narrow compass, that is the.
No, but then I don't find any infirmity in the way he's making his calculation also.
I agree, your lordship.
Yeah.
It might be correct. What
Yeah.
I am saying is this, in this proceeding, the supply code, which he is saying that should not be applied, supply code was the law in force at that point. Now, unless it is, without going into the merits, just on the procedural part, unless that supply code is declared to be ultra virus, your lordship, it will be the law that holds the field.
No, but then the supply code, let's go again to the supply code.
Lordship.
What does it say? The supply code says use of unauthorized electricity exceeding census for such nature assessment will be made for the category assessed consumption of detected category as per table 6.2.11 and connected load. Okay. But 2.1. Six point two. I'm not understanding this. Okay, you're talking about HT two.
Yes.
HT2, the estimated consumption is 150.
So he's been taking, he's
Page 1225.
perhaps this has been, because this was in 2007, perhaps this has been revised. Your lordship.
The problem is we cannot go on speculations. no?
Yes, your lordship. I just.
Your lordship accepts my interpretation. I have paid them more. In fact, I am entitled to a refund of 34 lakhs. That is my case before this honorable court. That is my specific prayer also.
Lordship will have the supply,
Can you bring someone who understands this jargon? I mean, it's why is it giving two different calculations?
no, Lordship will I'll just try and explain it to my limited understanding. For tea, coffee, perhaps his category is correct, is not HT2, his tea, coffee and
I
rubber.
don't know. That's what you were saying.
Yes, so it will be, your lordship will have this, have the chart
Yes.
and the assessment at page number 48 together.
Hmm.
The formula applied was 620 kilowatt, that is his sanction load,
Hmm.
620.
Correct.
The SS consumption per month is 200.
You
As-
see, just because you are sanctioned a
Yes.
particular load, does not mean that you use up a particular load. Sometimes it can go in excess of that load, no doubt,
Yes,
depending upon the transformer.
yes, it can.
But usually you don't hit that maximum amount.
We may, that
Yes, it
it will
comes-
depend on the industry,
So why are you calculating the sanctioned amount?
because that is because
sanction
as per
load.
the formula given, your lordship, it is sanctioned amount into 200.
But that does not seem to be in conformity with the Electricity Act.
But that has not been challenged in this proceeding.
That is, okay. Correct.
Because without there being a specific challenge, I cannot respond to it.
In fact, the appellate authority was conscious of that fact. So therefore, in appeal, they have reduced the amount. They have taken this off-season
Yes, the
peak
appellate
season-
authority has reduced.
peak season considerations into account. So they were aware of that.
Because out here in the calculation,
Yes,
as per the code, there is no peak season, off season, nothing.
yes.
But the appellate authority has reduced.
But
Is
they
it
were,
just-
they were perhaps aware of that fact. Actually, that is.
Perhaps, but I'm still, I do not know where you can,
But the manner in which the bill has been calculated, that is not correct.
that does not seem to be in conformity with the Electricity Act.
Yes.
That
But it is in
So-
conformity with the code, your lordship.
maybe, but the court cannot override the
Override
act.
the provisions
But
of
without
the
there
act.
being a specific challenge in this proceeding, I would not be able to respond to it, your lordship. That is because if they had challenged the virus of the act and it was struck down as ultra virus, then that would have been the end of the matter. But the act was in force at that, the code was in force at that point.
The code was in force, the act was in force also.
Act was
Yes.
also in force.
Which one do we
So-
take into account?
So unless it is struck down as ultra virus, your lord, because this is a statutory rule made under an act. So unless it is
This code is made under what?
section 50 of the act, your lord. Section 50 and 181. So unless it is struck down, your lordship, it will have to be given effect.
Why can't we read down the act?
Because they have not prayed for it, your lordship.
No, but we can still read down. We don't have, doesn't have to be,
Then
struck
your
off.
lordship may allow me, if your lordship is intended, the lordship may allow me to at least respond to it, your lordship,
Yes, you can respond.
by way of an affidavit, your lordship. Because challenging, if the code is read down, your lordship, it will have a ramification in many matters, not only in this case, your lordship. And here he has not, since he has not challenged the code, I have also not responded in my affidavit, your lordship. His only claim is that the code should not be applied, the act should be applied. And on facts, your lordship, the act has been applied in principle. 12 months, twice the tariff, and for the best judgment assessment part, as the formula was used to actually assess the number of units, and only for that part the code was used. Otherwise, the code is in conformity with the act as far as the 12-month period and twice the tariff.
No,
is concerned.
those part which is in conformity, that is okay. But that part which is not in conformity, that would have to be,
But if
that cannot be taken
Best
into
judgment
consideration.
assessment of the assessing officer, if the AERC in its rulemaking part seeks to prescribe some parameters.
But it
for-
cannot go beyond the provisions of the act.
But perhaps it has not, if your lordship may have the act once, perhaps it has not gone beyond the provision. Because as far as the number of units are concerned, your lordship, on that, the act, the section.
No,
is
the
cited.
unit is okay. Consumption, actual consumption is okay. But sanction load, by multiplying the same with the sanction load, I don't find the basis for coming. How do you calculate? You see, if that was the case, then in the electricity bill that you had given to him earlier,
Lordship.
that sanction load would always have to be a part of the bill.
Because that bill was as per the meter, your lordship. Now,
Correct.
here, this is a person who has indulged in unauthorized use of electricity. Now,
Is
once
why
that is done, once the meter is tampered with, in a tampered meter, there is no way for us to actually find out what was the actual consumption. So we'll have to come up with some formula where it is on some assumption. Because he's not challenged that finding that no, I have not tampered with the meter. He's saying that it should not, rather it should be as per the act or his understanding of the act. But since there is no way for us to actually find out what is the actual consumption in that meter, there has to be some parameters.
Let us see this section 50, what are this?
Yes, section 50 is a general rulemaking part, Your Lordship. 50 and 60 is it says the state commission uh, shall specify an electricity supply code to provide for recovery of electricity charges, intervals for billing of electricity charges, disconnection for supply of electricity for non-payment thereof, restoration of supply of electricity, measures for preventing tampering.
Is there any rulings earlier with regard to this? There must be.
Section 126 was
Yes.
interpreted by this Honorable Supreme Court, Your Lordship. I have the judgment here.
They also said it will be twice the amount, but as per the applicable
But
tariff.
in fact,
That is always there, tariff, that is there in 126.
Yes, 120.
126 was interpreted.
Does it speak of the code?
Yes, 126, the Supreme Court has said that it should be given a revenue focus. That even though otherwise fiscal statutes have to be strictly interpreted, there is an exception has been created out for section 126.
There is
If I may read from para 16 onwards,
16.
para 16.
Which one? Sitaram.
Sitaram Rice. First and foremost, we have to examine how provisions like section 126 of the 2003 Act should be construed. From the objects and reasons stated by us in the beginning of this judgment, it is clear that revenue focus was one of the principal considerations that weighed with the legislature while enacting this law. The regulatory regime under the 2003 Act empowers the Commission to frame the tariff, which shall be the very basis for raising a demand upon a consumer, depending upon the category to which such consumer belongs and the purpose for which the power is sanctioned to such consumer. We are not prepared to accept the contention on behalf of the respondent that the provisions of section 126 of the 2003 Act have to be given a strict and textual construction to the extent that they have to be read exhaustively in absolute terms. This is a legislation which establishes a regulatory regime for the generation and distribution of power, as well as deals with serious fiscal repercussions of this entire regime. In our considered view, the two maxims which should be applied for interpretation of such statutes are ex viceribus actus, construction of the Act as a whole, and ut regis magis valeat quam period. It is better to validate a thing than to invalidate it. It is a settled canon of interpretive jurisprudence that the statute should be read as a whole. In other words, its different provisions may have to be construed together to make consistent construction of the whole statute relating to the subject matter. A construction which will improve the workability of the statute to be more effective and purposive should be preferred to any interpretation which may lead to undesirable results. It is true that fiscal and penal laws are normally construed strictly, but this rule is not free of exceptions. In given situations, this court may, even in relation to penal statutes, decide that any narrow and pedantic literal and lexical construction may not be given effect to, as the law would have to be interpreted having regard to the subject matter of the offense and the object that the law seeks to achieve. The provisions of section 126 read 127 of the 2003 Act in fact become a code in themselves. Right from the initiation of the proceedings by conducting an inspection to the right to file an appeal before the appellate authority, all matters are squarely covered under these provisions. It specifically provides the method of computation of the amount that the consumer will be liable to pay for excessive consumption of the electricity and for the manner of conducting assessment proceeding. In other words, section 126 of the 2003 Act has a purpose to achieve, that is to put an implied restriction on such unauthorized consumption of electricity. Should I continue or not? The provisions of the 2003 Act, applicable regulations and the agreement executed.
See, one thing in that para 18,
Lordship,
the sixth line,
Lordship.
the provisions of section 126 read with section 127 of the 2003 Act, in fact, become a code in them.
Yes, Your Lordship. So, Your Lordship, 126, three parameters for calculating the charges: time period, units consumed, and tariff. As far as time period is concerned and tariff is concerned, we are not touching it. It is only as regarding the issue of units consumed. Now, the code says, if I may take Your Lordship to the code, section 126 says,
Code.
of the Act, Your Lordship, of the Electricity Act, section 126 says, if on an inspection of any place or premises or after inspection of the equipment, gadgets, machines, devices found connected or used, or after inspection of records maintained by any person, the assessing officer comes to the conclusion that such person is indulging in unauthorized use of electricity, he shall provisionally assess to the best of his judgment the electricity charges payable by such person or by any other person benefited by such use. Now, regarding the period and the tariff, we have not touched it. It is only the issue of how the assessing officer is to exercise his best judgment. There, the State Electricity Regulatory Commission, which is the rulemaking authority, has given a formula that the category-wise consumption, there is an estimate provided into 12. So that formula was applied in this case. Now that formula was the law which was holding the field at that point of time. So perhaps since we have not in any way diluted since the requirement is to give it a revenue focus, that's what the Supreme Court has said.
Maybe,
But we have not diluted it, Your Lordship.
but we have got to read the provisions of the act.
Yes, so regarding that part of exercising the best judgment assessment, we have laid down a formula. Unless that formula, Your Lordship, is so, though it is not under challenge, I'm still saying, though, unless that formula is violative of section 126, that it is in the teeth of 126, that it completely negates what the purpose of 126 is. That is to ensure that unauthorized use of electricity is restricted and revenue focus is protected. So unless it is a teeth of 126, perhaps it is, even if my learned friend had challenged it, Your Lordship, perhaps it would still have survived.
If your lordship permits me, I want to say one thing.
Because otherwise, in a tampered meter, Your Lordship, there is no way of finding out what is the actual amount of electricity consumed. And if the formula is not there, if only best judgment is, if it is just left to the assessment of the assessing officer, perhaps it can give rise to a situation where it might be very arbitrary also.
Out here in 125, 126.5, it has said that the period which such unauthorized use of electricity has taken place,
Yes,
such period shall be limited to 12 months.
12 months.
Immediately preceding the date of inspection.
Yes,
The assessment under this section shall be made at a rate equal to twice the tariff.
yes, twice the time.
What do you mean by tariff? According to both of you, does it mean the actual consumption?
Tariff would mean the rate fixed by the AERC per unit of electricity consumed.
So how do they fix the rate of electricity?
They have been given a power to fix the tariff also. Your Lordship.
So let
Yes.
us see where is this definition of tariff? Is it in the code? It's not in the
It
code.
is not there in the code also.
Lordship will kindly see one more thing. Lordship has seen an exercise. The manner in which the bill has been prepared. Lordship, the final bill is 1,50,00,000, 9,966. The fact that during this preceding 12 months, I had paid 42 lakhs and all, that has not been taken into consideration. So something is wrong in the manner in which the bill has been prepared, Lordship.
No, you see,
The calculation is not correct.
correct. It has been done completely at variance with this
Yes. Done
125.
in a very, Lordship will, when I.
You have got to justify this page
Yes.
48. How do you justify page 48?
Lordship,
Let us see your code.
yes, Your Lordship.
Your code also.
And the fact that the amount paid should be taken into consideration, amount paid in the preceding 12 months, the Kerala High Court judgment says so, Lordship.
You see, even the code says, then the consumer is liable to pay compensation bill at a rate of 1.5, which becomes 2 of the normal tariff applicable to the purpose for which the electricity is misused for the entire consumption period of 3 months. No, that's become 12 months.
If the exact period cannot be
Lordship is reading
determined.
from
Okay. 5.4.5 4.1, no?
5.8.4.4.
4.4. Yeah, 4.4. 4.4. When the consumer indulges in access the quantum of electricity loss on the basis of assessed consumption
Yes.
of detected category as per 6.2.11 and connected load. So 6.2.11.
There the petitioner's category.
You see, there is nowhere that it says that your sanction load should be taken into account, should be calculated. You have, however, in your page 48,
Lordship,
you have assessed the consumption
Lordship.
by adding this 620. Now, let us see his bill. In his bill, is there any addition of the actual consumption of units with 620?
620.
620 is not mentioned the sanction load is not mentioned in the code also. So how did you bring into how did you bring into the picture this code?
Previous electricity bill.
Now, Lordship, now I understand that the.
Yes, it is there at Annexure 1,
That the regulatory commission has
page number 30,
rectified the manner of calculation.
page number.
I
Now,
think my,
yes, now it
my
is
learned friend will be able to enlighten us on that count. Now I
Hey?
think the
page 34.
manner of correct, I mean, calculation of bill that has been rectified. There was something wrong with the code then.
No, not rectified, it's almost the same formula.
Yes, see?
Number of load applied for sanction, 620 kilowatt.
Yes,
Serial number 3.
yes,
That is what, that is the sanction load that has been applied.
correct.
So, Lordship,
You see, it's like this. For this high court, the needs, the electricity needs for this high court is based on the electrical connections that we have. So we are going to need, say, a mini transformer for this building, which may be a 500 kilowatt kV, or maybe 1000. But it doesn't mean that just because we have got a transformer which can take that load and distribute it to all the various points in this building, doesn't mean that we use up just because we have taken this much load, doesn't mean that we use up this much load, this
Yes.
much electricity.
yes,
So why do you calculate the sanction load when you're not using that load? And you have to only calculate the consumed units
yes.
into 2. Not the sanction load.
But
Why
your
do-
Lordship, in this case, we have no idea of knowing what is the consumed units.
That is why you have that thing. You have the chart.
Yes,
That chart is there for T, it is 200.
yes,
So, when is that?
yes,
6.2.1.
6.2.2.2.
So 6.2.1.1.
Yes,
It says here,
yes, that is there.
it says here, the new sensor as per estimated consumption per kilowatt per month.
Yes. Tea, coffee and rubber is 200.
200.
200.
So it is for those for which you do not know how
Yes.
much the electricity they have consumed.
Yes,
You can always take the help of this chart and say that here tea, coffee is 200. Otherwise, how are you going to base?
Lordship may have the matter on next week on a hearing day. I'll just get an instruction on this, just on this.
You get on this
On
and
this.
also on why are you taking into account the sanction load?
Very well.
One thing is during the making of an electricity bill, is the sanction load also calculated? Is it also multiplied with the actual consumption
Very,
of units?
very.
If it is not, if it is done well and good, then it's all right. But if it is not, then why put it now at the time of penalty
So,
and not at the time of making the electricity
so
bill?
if in a regular billing period, if his amount of units consumed is 100, then I have to take instruction if it is 100 into 620 or not
Yes, yes.
for that particular.
Yes,
month.
yes.
Very well. I'll get that.
That will clarify everything
yes.
because we have got no idea.
Very well. I'll get that.
Correct. heard Mr.
P. Bhumi.
P. Bhumi, learned counsel for the petitioner, and Mr. K. P. Patak, learned counsel for the APDC. The petitioner's case is that that in terms of section 126 bracket 5 of the Electricity Act, 2003. The one 26.5, no? The assessment to be made for unauthorized units, for unauthorized use of electricity would have to be calculated on the basis of the units of electricity consumed for a period of 12 months. And the assessment would have to be made at a rate equal to twice the tariff applicable for the relevant category of services specified in section 126 bracket 5. The petitioner's counsel submits that as the petitioner's electricity bill for the last 12 months was rupees 42,26,618. The petitioner would have to pay an additional 42,26,618 in terms of section 126.5 of the Electricity Act, 2003. On the other hand, Mr. K. P. Patak has taken this court to, which page is that? That billing amount? Taken this court to page 46.
Yes, Your Lord, 48. The assessment is at 48.
Page 48. To show that the petitioner was to pay 1,50,09,966 for theft of electricity,
For
Theft.
theft of electricity,
For theft.
malpractice.
for theft/malpractice of electricity in terms of
Clause 5.8.
clause 5.A.4.4 and clause 6.2.1.1 of the Assam Electricity Regulatory Commission bracket Electricity Supply Code and related matters, regulation, which 2000,
4,
Four.
amended in 2007.
2004, which was amended in 2007. Which has been, no, full stop, here and after referred to as the supply code. He submits that the supply code was made in exercise of the powers conferred by section 50 and section 181 of the Electricity Act, 2003. Next paragraph. And on perusing the assessment made by the respondents, at page 48 of the writ petition, it is seen that the respondents have also taken into account the sanction load of 620 kW given to the petitioners while calculating the assessment.
And Lordship, they have also not taken into consideration the amount paid by me.
No, that's a different. There is nothing stated in the Electricity Act 2003 as to whether the sanction load is also to be taken into consideration while making an assessment under section 126(5) of the Electricity Act 2003.
The assessment is under one. The formula is in five, the manner. Assessment
Correct.
is under one.
Correct. But one also doesn't say anything.
So one also doesn't say anything.
Then the next, the Mr. K.P. Patak shall accordingly obtain instructions as to whether the sanction load of any business slash household, etc., is taken into reckoning while making an electricity bill in the normal course of business. If not, he should obtain further instructions as to why the same has been taken into consideration while assessing the payment to be made by the petitioner. Leaves the matter
21st be convenient for a lordship.
anytime. I'm not, I won't be here.
21st.
21st. Is my.
I'll give it to Nihal.
Thank you, Lordship. Lordship, is an application under
This
section.
also. Yes,
Lordship, is an application under section 11 of the Arbitration Conciliation Act. Lordship may kindly peruse the order dated 28/2 for a brief idea as to the facts of the case and the arguments raised so far. Lordship, 28th of February.
yes.
May I read the Lordship? Lordship, from para 3. The petitioner's case is that the petitioners have appointed the arbitrator. However, despite receipt of the arbitration notice from the petitioners by the respondents have till date not appointed the arbitrator. The claim of the petitioners is this case is only with respect to the interest on the amount that have been paid by them for their apartment from 21/12/2020 till anti-closure possession of their apartment. The facts of the case is that the petitioners and respondents executed an agreement for sale of an agreement on 24/1/2017. And as per the terms and conditions of the said agreement, the respondent number 1 was to deliver possession of the apartment on 20th December 2020. The petitioner is accordingly pay 95% consideration amount of the apartment, and the remaining 5% must be paid at the time of handing over the possession of the said apartment. However, as this apartment was not handed over to the petitioner was claiming interest as per provision of section 18 of the RERA Act 2016 and clause 11.3 of the agreement. The petitioner's counsel submits that in terms of the judgment of the Delhi High Court in the case of Priyanka Takshud and others versus Sunwall Residency Private Limited, reported in 2022 SEC Online Del 4717, the Honorable Delhi High Court has held that adjudication of a dispute in terms of the arbitral clause between the parties was not barred by the existence of a concurrent remedy under the RERA Act 2016. The petitioners have also relied upon the judgment of the Honorable Supreme Court in the case of Srimati M. Himalata Devi and others versus D. Udaysri, reported in 2023 SEC Online SC 1686, where the Supreme Court has referred in another of its judgment, that is MRMGS Land Limited versus Aftab Singh, reported in 2019-12 SEC 751, and held that an option is left to the party to choose between a public or private forum and the party may choose to go for a private forum. Paragraph 63 of the judgment states as follows. We may, however, hasten to add that in the event of a person entitled to seek an additional special remedy provided under the statute does not opt for additional special remedy and is a party to an arbitration agreement, there is no inhibition in the disputes being proceeded in arbitration. It is only the case where the specific special remedies are provided for and which are opted by an agreed person, the judicial authority can dismiss to delegate the parties to an arbitration. The petitioner's counsel submits that in the case of Imperial Structures versus Anil Patni and other reported in 2020, 10/67/83, the Supreme Court held that merely because the registration of the RERA Act is valid till a certain date does not mean that the entitlement of the allotted consent to maintain an action plan difference in terms of the extension given to the validity of the registration of the builder under the RERA Act 2016. We submit that in terms of the said judgment, the period for the purpose of Section 18 has to be retained in terms of the agreement and not the registration of the RERA Act. On the other hand, the learned counsel of the respondents submits that in terms of the judgment of the Honorable Supreme Court in Vidya Jolly and others, versus Durga Trading Corporation reported in 2021 2861 at para 55 to 58 and 78 and 79. The doctrine of election is to select arbitration as a dispute resolution mechanism by mutual agreement is available. Only if law accepts the existence of arbitration as an alternative remedy and freedom to choose is available. Further, the Supreme Court in Vidya Jolia had held that disputes which are to be adjudicated by DRT under the DRT Act are not arbitral, as the DRT is a complete code by itself, so far as recovery of debt is concerned. He thus submits that the same analogy will be applicable in respect of the RERA Act. The learned counsel of the respondents has also relied upon the judgment of the Supreme Court in the case of NTPC Limited, was SPML Infra Limited, reported in 2023, 9 SCC 385 at para 25 to 28, wherein the Honorable Supreme Court has held that the first inquiry to be made in respect of 11, 6A of the 1996 Act would be with regard to existence and validity of an arbitration agreement, and secondly, as to whether the dispute was arbitrable. Lordship, thereafter, the next date, I had made a distinction. Lordship, my learned senior was relying on the analogy of the Vidya Jolia, that since DRT judgments, DRT cases are not arbitrable, the same analogy will follow in this case also. Lordship, I made a distinction. For a Lordship convenience, I'll make the
Yes,
distinction.
please, again. I don't remember.
Lordship. Lordship, may kindly have section 18 of the RERA Act.
RERA Act.
Lordship.
Where is the RERA Act? Section
18, Lordship.
Yes.
Returns of amount and compensation. If the right, Lordship, my right, when the apartment is not completed within the due time as the contractual period, then what happens? This talks about by right. If the promoter fails to complete or the honorable Supreme possession of an apartment, plot or building in accordance with terms of the agreement for sale, or as the case may be, duly completed by the date specified therein, or due to discontinuance of his business with the developer on account of suspension or revocation of the registration under this act, or for any other reason, he shall be liable on demand to the allotee in case the allotee wishes to withdraw from the project without prejudice to any other remedy. Lordship, this is where I will come back to this later on. To return the amount received by him in respect of the department, lot, building, as the case may be with interest, at such rate as may be prescribed in this behalf, including compensation in the manner provided as provided under this act. Provided that where an allotee does not intend to withdraw from the project, he shall be paid by the promoter interest for every month of delay in the handing over the possession at such rate as may be prescribed. Lordship, we are falling under the second category. We are not seeking the cancellation amount, we are seeking interest till the flat is handed over to us. Now, Lordship, the process for adjudication of this right.
No, you see, this, he shall be liable on demand to the allottees in case the allottee wishes to withdraw from the project
Lordship.
without prejudice to any other remedy available to return the amount received by him in respect. So this is with regard to return of the money.
Lordship, now the second provision, provided that where an allotee
Yeah.
does not intend to withdraw from the project, he shall be paid by the promoter interest for every month of delay. So Lordship, we fall under the latter category. Now, Lordship, the process for adjudication of this dispute is there in section 71 of that. Lordship,
Yes.
Lordship, power to adjudicate. For the purpose of adjudicating compensation under section 12, 14, 18, and 19, the authority shall appoint in consultation with the appropriate government one or more judicial officers as is necessary, who is or has been a district judge to be an adjudicating officer for holding an inquiry in the prescribed manner after giving any person concerned a reasonable opportunity of being heard. Now, Lordship, this provision is akin to section 19 of the Recovery of Bank Debt due to Bank and Financial Institutions Act, which is the DRTS. Lordship, may kindly have the DRTS for a while.
DRT Act.
Recovery.
Section,
In 19, Lordship. The adjudicating part.
yes,
Under this act, what happens is that whenever a debt is due from a borrower, the banks have the right to file their cases before the DRT under section 19. Under section 19, the adjudication takes place, and if the DRT is satisfied, a recovery certificate is issued under section 1922. After that, Lordship, they kindly come to section 25.
this is. Section 25 of,
Of the DRT, so of the recovery of debts and bankruptcy.
yeah,
A recovery of debts determined by tribunal. Use of recovery of debts.
yes,
The recovery officer shall on receipt of the copy of the certificate under subsection 7 of section 9, proceed to recover the amount of debt specified in the certificate by one or more of the following modes, namely attachment and sale of the movable or immovable property of the defendant, taking possession of the property over which security interest is created, or any other property of the defendant, and appointing receiver for such property and to sell the same. The rest of the defendant and his detention is legal. Appointing a receiver for the management of the movable or the immovable property of the defendant. Any other mode of recovery as may be prescribed by the civil council. Now, Lordship, may kindly come to para 29, section.
this,
29.
wait a minute.
Sorry.
There are 25, you said, no?
Lordship, section 29.
Section 25,
29,
29.
Lordship.
No, no,
25 and then 20.
this edition is what edition?
Oh, my. Whole.
Lordship, the recovery of
2010 edition they've given.
My,
That's yours. DRT Act, just look at DRT Act.
we mean to teach here, so it will be what?
Their copy is very outdated.
Out. We go to na,
Yes,
Lordship, just give me 1 second.
Not really.
Debt Recovery Tribunal.
Recovery
The
of
recovery
debts
of debts.
are already started. Recovery of
The
debts.
Recovery of Debts and Bankruptcy Act. The Recovery of Debts and Bankruptcy Act. Where is he gone? Where is he gone here? Huh? Bathroom. देखो ऑफिस में चेम्बर में है क्या? Okay, got it, got it. Hmm. I give it to you. Thank you. Good.
I'll take a Lordship for section 25, Lordship. Move the recovery of debts. Lordship, have it?
Yes,
Lordship, the recovery officer shall on receipt of the copy of the certificate under subsection 7 of section 19, proceed to recover the amount of debt specified in the certificate by one or more of the following modes. Namely, attachment and sale of the movable or removable property of the defendant, taking possession of property over which security interest is created, or any other property of the defendant, and appointing receiver for such property and to sell the same. Arrest of the defendant and his detention in prison, appointing a receiver for the management of the movable or removable properties of the defendant, any other mode of recovery as may be prescribed by the central government. Thereafter, Lordship may kindly come to section 29. Application of certain provisions of the Income Tax Act. Lordship, have it?
Yes.
The provisions of second and third schedules to the Income Tax Act 1961 and Income Tax Act Certificate Proceeding Rules 1962, as in force from time to time, shall as far as possible apply with the necessary modifications, as if the said provisions and the rules refer to the amount of debt due under this act instead of to the Income Tax Act. So, Lordship, it is in view of these provisions from section 25 to section 30. Did the Supreme Court, the Honorable Supreme Court in Vidyadolia say that DRT disputes are not arbitrable? Because, Lordship, that deprives the banks from taking benefit of this special mode of recovery. Because in arbitration, adjudication can take place. But the special modes of recovery which are there built in this act, that will not be applicable to arbitration. That will defeat the very object and purpose of that action.
Yes.
Lordship, in the Vidyadolia case, it was held by the Honorable Supreme Court that for in the Vidyadolia case, Lordship, it was held that for arbitration to be as a bar, as an alternative remedy, what has to be seen is that whether there is any inconsistency or repugnancy in the statutory law, between the statutory law and arbitration as an alternative. And for that, what is to be seen is the text of the statute, the legislative history, and the inherent conflict. In the DRT case, Lordship, the arbitration would have defeated the very purpose and object of that, and hence it was held to be non-arbitrable. But in the present case, Lordship, in the instant case, the functions of RERA will nowhere be hampered if we are given the opportunity of arbitration.
Yes.
Lordship, my second follow of the argument will be as to whether in spite of the provision of section 71, can other foras be chosen by the home buyers to agitate their grievances? Lordship will find that in the Imperia judgment, Imperia structural judgment. Inferior structures limited was running Patni.
Yes.
Lordship has the judgment.
Yes.
Lordship may kindly come to para 25.
25.
Lordship.
Yes.
In terms of section 18 of the RERA, if a promoter fails to complete and is unable to keep possession of an apartment duly completed by the date specified in the agreement, the promoter would be liable on demand to return the amount received by him in respect of the apartment if the allottee wishes to withdraw from the project. Such right of an allottee specifically made without prejudice to any other remedy available to this. Lordship, the emphasize I was relying
Correct.
on.
That is only with regard to if he wants
No,
to
Lordship,
withdraw.
The second provision also discussed here. The right.
But won't is the second provision that right to the other remedy that has not been mentioned in the second point.
Lordship, in this paragraph, the rights to given to the allottee is unqualified and if available, the money deposited by the allottee has to be refunded with interest at such rates as may be prescribed. The provision of section 18 subclause 1 contemplates a situation where the allottee does not intend to withdraw from the project. In that case, he is entitled to and must be paid interest for every month of delay till the handing over the possession. it is up to the allotee to proceed either under section 18(1) or provision or under provision to subclause 18, subclause 1. The case of Himanshu Giri came under the latter category, similar to our case also. The RERA Act thus definitely provides a remedy to an allotee who wishes to withdraw from the project or claim return on his investment. Now, Lordship, it is therefore required to be considered whether the remedy so provided under the RERA Act to an allotee is the only and exclusive modality to raise a grievance, and whether the provision of the RERA Act bars consideration of the grievance of an allotee by other fora. Section 79 of the RERA Act bars jurisdiction of a civil court to entertain any suit or proceeding in respect of any matter which the authority of the adjudicating officer or the appellate tribunal is empowered under the RERA Act to determine. Section 88 specifies that the provisions of RERA Act would be in addition and not in derogation of the provisions of any other law, while in terms of section 89, the provisions of the RERA Act shall have effect notwithstanding anything inconsistent contained in any other law for time being in force. On plain reading of section 79 of the RERA Act, an allotee described in clause B, stated in para 44 hereinafter, would stand barred from invoking the jurisdiction of a civil court. However, as regards the allottees who can call consumers within the meaning of the Consumer Protection Act, two questions would arise. A, whether the bar specified under section 79 of the RERA Act would apply the proceedings initiated under the provisions of the Consumer Protection Act, and B, whether there is anything inconsistent in the provisions of the Consumer Protection Act with that of the RERA Act. Lordship, thereafter, in Malay Kumar Ganguly and Sukumar Mukherjee, it was held by this court. The proceedings before the National Commissions are all the judicial proceedings, but at the same time, it is not a civil court within the meaning of the provisions of the Code of Civil Procedure. It may have all the trappings of a civil court, but it yet cannot be called a civil court. Lordship, now I pause here for a bit. Lordship, even arbitral tribunal is not a civil court. I take in Lordship to the judgment of the Bombay High Court. That arbitral tribunal is also not a civil court because section 3 of the Evidence Act specifically defines court and excludes arbitrators.
Yes.
Lordship, continuing on para 30, on the strength of the law so declared, section 79 of the RERA Act does not in any way bar the commission or forum under the provisions of the Consumer Protection Act to entertain any complaint. Provision section 71 subclause 1 of the RERA Act entitles the complainant who had initiated proceedings under the Consumer Protection Act before the RERA Act came into force to withdraw the proceedings under the Consumer Protection Act with the permission of the forum or commission and file an appropriate application before the adjudicating officer under the RERA Act. The provision thus gives a right or an option to the complainant concerned but does not statutorily force him to withdraw such complaint, nor do the provisions of the RERA Act create any mechanism for transfer of such pending proceeding to authorize under the RERA Act, as against the mandate in section 12 subclause 4 of the CP Act. To the contrary is quite significant. Again, insofar as cases where such proceedings of the Consumer Protection Act are initiated after the provisions of RERA Act came into force, there is nothing in RERA Act which bars such initiation. Lordship, this part is important. The absence of bar under section 79 is the initiation of proceedings before court and which cannot be called the civil court, and express savings under section 18 of the RERA Act makes the provision quite clear. Section 18 itself specifies that the remedy under the section is without prejudice to any other remedy available. Thus, the parliamentary intent is clear that a choice or discretion is given to the allotee whether he wishes to initiate appropriate proceedings under the Consumer Protection Act or file an application before the RERA Act. It was, however, the Lordship, there was another submission that was made. It was, however, argued that going by the objectives for the purpose of which the RERA Act was enacted and considering the special expertise and the qualifications of the chairperson and members of the authority, the 22 and the Appellate Tribunal section 46, such authorities must alone be entitled to decide on the issues concerning the project registered under the RERA Act. It was submitted that if the allottees were to be permitted to initiate parallel proceedings before the fora under the CP Act, the financial drain on the promoter would render completion of the construction of an impossibility, and therefore the RERA Act in general and section 89 in particular be construed in such a way that all the issues pertaining to the project concerned may be decided only by the authorities under the RERA Act. Even with the acceptance of such interpretation, the allottees would still be entitled to approach the authorities under section 18 of the RERA Act. Your Lordship, the submission that was made was that the RERA is a technical body, and there are certain aspects which can be taken care by the technical, because it consists of a chairperson and technical assistance is required under section 34. consideration. It is under section 18, which also provides for additional remedy. This is what the Honorable Supreme Court has held, Lordship. Lordship, carrying on, it is true that some special authorities are created under the RERA Act and for the regulation and promotion of the real estate sector, and the issues concerning a registered projects are specifically entrusted to functionaries under the RERA Act. But for the present purpose, we must go by the purport of section 18 of the RERA Act, since it gives a right without prejudice to any other remedy available. In effect, such other remedies acknowledged and safe, always subject always to applicability of section 79. At this stage, we profitably refer to decision in Pioneer Urban Land Infrastructure Limited versus Union of India. So, Lordship, after the enactment of the RERA Act, there was an amendment which was carried out in the IBC, the Insolvency Bankruptcy Code. Therein, Lordship, under section 7, a home buyer has been given has been upgraded to the status of a financial creditor. Even a home buyer can now trigger the IBC code if the amount he has paid is above the certain threshold limit required for IBC. He can now also trigger the IBC code. So, Lordship, that amendment was challenged before the Honorable Apex Court as being inconsistent ultra-wise of Article 14, 19, and also ultra-wise of the RERA Act. Lordship, this is what the Honorable Apex Court held. RERA is to be read harmoniously with the code as amended by the Amendment Act. It is only in the event of conflict that court will prevail over the RERA. Remedies that are given to allottees of flats apartments are therefore concurrent remedies. Such allottees of flats apartments being in a position to avail of remedies under the Consumer Protection Act 1986, RERA, as well as of triggering of the code. Thereafter, Lordship, the conclusion is made at para 36. We therefore reject the submissions advanced by the appellant and answer the questions raised in para 28 herein above against the applicant.
Where is the arbitration clause here?
Page 39, Lordship.
Where
I'm
exactly?
sorry, Lordship, page 59. Page 59, clause 16. 16 A, B, C, D, E, F.
Is the heading.
Heading is page 58. 59 is last, Lordship.
Page 50.
Lordship, there is another judgment that we're relying on.
On what?
For what proposition of law?
Lordship, that whether RERA is the only fora or whether arbitration can be invoked in view of the provisions of RERA Act.
So similar to this Imperial.
Lordship, no, Lordship, it's similar to Priyanka Takshud of the Delhi High Court. Of the Patna High Court.
Party name? When? Thank you.
What is the case, is it?
Lordship, BR Home Developers. Lordship, earlier I had referred to Priyanka Takshud.
Yeah.
So, Lordship, this is another case wherein the Patna High Court has also taken the question as to whether arbitration can be invoked in view of the provision of the RERA Act.
Hara?
Lordship, before going to the judgment, Lordship may kindly have a look at section 88 of the RERA Act once.
Yes.
Application of other laws not barred. The provisions of this act shall be in addition,
Just
And-
a minute.
Lordship, section 88,
88.
Lordship, of the RERA Act.
Yes,
applications of other laws not barred. The provisions of this act shall be in addition and not in derogation of the provisions of any other law for the time being in force. Now, Lordship may kindly come to the Bihar High Court judgment, Patna High Court judgment. From paragraph 21, Lordship. What further requires consideration is the factor of the petitioner applying the authority
which
constituted.
para?
Para 21, Lordship.
Yes,
What further requires consideration is the factor of the petitioner applying the authority constituted under the Real Estate Regulation and Development Act 2016. Is it a valid ground or reason sufficient enough to reject the instant application? The object and purpose of both the statutes are distinct and different, and there is nothing inconsistent or derogation therein. The Arbitration Act was enacted to consolidate and amend the law relating to domestic arbitration, international commercial arbitration, and enforcement of foreign arbitral awards, and also to define the law relating to conciliation and for matters connected therewith or incidental thereto. Whereas the RERA Act was enacted to establish the Real Estate Regulatory Authority for regulation and promotion of the real estate sector and to ensure sale of plot of land, apartment or building as the case may be, or sale of real estate project in an efficient and transparent manner, and to protect the interest of consumers in the real estate sector and to establish an adjudicating mechanism for speedy dispute redressal and also to establish the appellate tribunal to hear appeals from the decisions, directions, or orders of the Real Estate Regulatory Authority, an adjudicating officer, and for matters connected therewith or incidental thereto. Section 88 thereof provides the provisions of this act explicitly to be in addition and not in derogation of the provisions of any other law, with only limitation contained in section 89 making it prevail over any other inconsistent law. Reading of both the statutes do not make the Arbitration Act to be inconsistent with the provisions of the RERA Act, more so when respondent number 1 himself disputes its applicability for the want of jurisdictional issue. In management committee of Montfort Secondary School versus Vijay Kumar, the Honorable Apex Court dealt with the ambit and scope of the Delhi School Education Act 1973 vis-a-vis the provisions of the Arbitration and Conciliation Act 1996. The issue arose as to whether the tribunal for the Arbitration Act can be said to be a judicial authority or not. Clarifying it not, the court reiterated that plaintiff is dominus litis, having dominion over his case. He is the person who has carriage and control of the action. In case of conflict of jurisdiction, the choice ought to lie with him to choose the forum best suited unless there be the rule of law excluding access to a forum of his choice, permitting recourse to a forum as opposed to public policy or would be an abuse of process of law. The court reiterated its earlier principle laid down in Bank of India versus Lekhi Mohandas that as a general principle where two remedies are available under the law, one of them need to be taken as an operating derogation or of the other. Lordship.
The issue arose as to whether the tribunal for the Arbitration Act can be said to be a judicial authority or not.
Lordship.
It said that it cannot be.
Lordship.
It's not a judicial
Lord-
authority.
Lordship, no, that's the Lordship had raised the query as to there is in section 79, the term any other authority is used. Lordship had raised this question on the previous date. So Lordship, there is a judgment of the Honorable Bombay High Court that arbitral tribunal will also not come under the ambits of any other authority.
No, it will not come. No, but is it a judicial authority?
It's a quasi-judicial authority. Lordship.
It's a judicial authority.
It's a quasi-judicial
Huh?
authority.
Is it a judicial authority?
It's a quasi-judicial authority, Lordship.
So basically a
But
judicial authority
without the trappings of a court,
without the trappings of a court.
Lord.
But it is a judicial authority.
it's a quasi-judicial authority, Lordship.
Ah.
It is. Lordship, there has been para 25 in MD Frozen Foods Exports Private
Just
Limited.
a minute.
Lordship.
Yes.
In MD Frozen Foods Exports Private Limited versus Hero FinCorp Limited, 16 SCC 741, the Honorable Apex Court held that proceedings both under the Arbitration Act and the SURFACE Act could continue simultaneously. The Lordship, SURFACE Act and DRT Act are kind of similar in nature. And in Vidya Jollia's judgment, Lordship, this judgment was also taken into consideration. But while DRT proceedings were held to be arbitrable, non-arbitrable, SURFACE proceedings, this judgment was not set aside. It is only the other judgment which was set aside. From the aforesaid reason, it cannot be said that the petitioner's right is foreclosed in light of the Red Act. They had an equally alternative and efficacious remedy of adjudication under the said act. They waive off their right to invoke clause 17 for resolution of disputes to arbitration, or that they elected not to enforce their statutory rights under the Arbitration Act. So, Lordship, under the doctrine of election, it is my right, and under which fora to go. But once I've elected, I've chosen that right, then my right is gone. Then I cannot come back and say I cannot choose. I have to go to the other fora.
That's all?
Yeah, Lordship.
Lordship, a short reply.
Hope so.
Lordship, in the present case, there is no dispute that there is an arbitration agreement. There is an arbitration clause. The only dispute that Lordship is adjudicating is regarding the arbitral, whether there exists an arbitral dispute or not. Lordship may take the judgment for once, the Vidya judgment. So it's just to show paragraph 78.
Yes,
We have, paragraph 70 has been read, but just for understanding the issue in hand, paragraph 78.
Para 78.
78. We had read it earlier, Lordship, but I'd like to read it once more.
Yes,
May I read, Lordship?
yes.
In view of the aforesaid discussions, we overrule the ratio in N. Radhakrishnan inter alia, observing that the allegations of fraud cannot be made a subject matter of arbitration when they relate to a civil dispute. This is subject to the caveat that fraud, which should vitiate and invalidate the arbitration clause, in an aspect relating to non-arbitrability. We have also set aside the full bench decision of the Delhi High Court in the HDFC Bank Limited, which holds that the dispute which are to be adjudicated by DRT under the DRT Act are arbitrable. They are not arbitrable. Now, the reasoning for this, in my respectful submission, can be found in para 55 of the same judgment. Para 55 maybe. The other paragraphs are also relevant, but I'd like to stress on para 55.
Yes.
May I read, Lordship? Doctrine of election to set arbitration as a dispute resolution mechanism by mutual agreement is available only if the law accepts existence of arbitration as an alternative remedy and the freedom to choose is available. There should not be any inconsistency or repugnation between the provisions of the mandatory law and the arbitration as an alternative. There is an N. That means there should not be any repugnation between the two acts. Going ahead, conversely, and in a given case, when there is a repugnancy and inconsistency, the right of choice and election to arbitrate is denied. This requires examining the text of the statute, the legislative history, and the inherent conflict between arbitration and statute's underlying purpose, with reference to the nature and type of special rights conferred and power and authority given to the courts or public forum to effectuate and enforce these rights and the orders passed. When arbitration cannot enforce and apply such rights or the award cannot be implemented and enforced in the manner as provided and mandated by law, the right of election to choose arbitration in preference to the courts or public forum is either completely denied or could be curtailed. In essence, it is necessary to examine if the statute creates a special right or liability and provides for the determination of each right or liability by the specified code or public forum so constituted, and whether the remedies beyond the ordinary domain of the civil courts are prescribed. When the answer is affirmative, arbitration in absence of special reason is contradicted. The dispute is non-arbitrable. So, in my respectful submission, if we take the RERA Act, section 35 may be produced.
Just a minute, just before we go, just let me read this.
as my
Just a minute. Yes,
Lordship, may peruse section 35 of the data. Act. Here, the repugnancy I want to put forward is would be evident from once the section 35 is perused of the data. Act.
yes.
Powers of the authority to call for information, conduct investigation. When the authority considers it expedient to do so on a complaint or suo motu relating to this act or the rules or regulation made thereunder, it may, by order in writing and recording reasons therefore, call upon any promoter or LOT or a real estate agent. Was in your lordship. Here the authority on and complaint by the any person aggrieved or suo motu, the power is on the is vested on the authority. Now, in my respectful submission, your honor, your lordship, the section 18 petition, the section complaint under section 18 by which the interest will be awarded, it will require an investigation probably as to what had happened and what had not happened to the project and other things. So this power under the authorities that has been given, this power is not there under the Arbitration Act. The only power akin to Arbitration Act, I must respectfully submit, is given under whereas expert body can be called under the Arbitration Act, an expert body can be called, but it has to be at the consent of both the parties.
Why should you not consent?
No, there is a rider to. In my respectful submission, there is a rider to it. That is my submission. That is for the court to consider. My submission is that here the authority has the power either on a complaint or a suo motu.
Hmm.
There, the power. I just had noted down. It's a.
No, out here, it is not in dispute that you have not handed over the flat.
No.
On a certain date.
Yes, for not handing over the flat.
For
in this-
whatever reason.
Yes, the reasons, whether the flat is ready, everything, the fire license is not, we are not getting the fire license for a specific reason, whatever is the thing, the authority can,
So why can't the arbitrator decide?
in my respectful submission, the reading of 55 is there, and the Arbitration Act does not provide for this. Further, the section 59 to 72, 59 to 72, 68 talks about the penalty. So my submission, your lordship, is that here when this is a complete code like the DRT, here the arbitrator, when the learned Supreme Court had said that this requires examining the text of the statute, the legislative history, and inherent conflict. The arbitrator cannot go impose any penal clause.
No, good for you. Why
That
you
is
why
there.
you want to help them?
No, I am on the legal point. That's the thing. I am on the point that see, if the authorities tomorrow, when the authorities will adjudicate regarding whether I'll get an interest or not, the authority will call for a report. That's what happens before the data. They will call for a report as to how it
goes and what was the reasons and the extension part, and those would be adjudicated, which will be deprived in my respect, in my case. So this is my point.
You will be deprived.
I'll be deprived because the authority will be able to take all because the flat is it's ready. But only point is that nowadays occupancy certificate is not given if
Is there any technical issue that is involved here?
the fire license, why it is not issued.
Is there a technical issue?
The technical, if it is not issued, the fire license department will come to the authority and they will say, so these are the technical issues. Whether these technical issues are actually at the behest of the builder or it is at the behest of someone else or what, because as Lordship will remember, this case has a checkered history when because of a wall, we were deprived, the fire license was stopped. Because of a wall, the fire license was because the entry, there's a phase.
I'm not very into those.
I'm not married at all, Lordship. My submission would be the other, in addition to the earlier submission.
In
When-
Vijay Doyle, what does it say? That if there is an arbitration clause and if there is and if it is arbitrable, then
If it is, my submission is based on it's not arbitrable.
why
It's
is it not arbitrable?
Because it is not in the other earlier judgment, whatever judgments that have been cited by my friend for extremely submit that is only have a persuasive value. It's up to Lordships whether or not
Correct, correct.
that's a persuasive value. But they have not dealt to this aspect of section 35 and section 69 to 70, where they have not dealt paragraph 55 of Vidya Tolia. They have all throughout said about section 78, wherein RERA says that it is in continuation, not in derogation, which I feel agree. There is no dispute to that fact. But when the Supreme Court came to a finding that DRT is not applicable, that finding is based on this reasoning. That DRT is a whole court, there are the various measures, which he himself said. There is a bank should not suffer, which in the same way, when the RERA Act clearly envisaged.
But when you both have agreed that any dispute will be decided through arbitration, can you resile from that clause that has been made and agreed by both of you?
If statutorily it is not allowed, because I cannot agree to
Show me where it is not allowed. Directly. Where is the repugnancy? Where is the inconsistency? The only thing you are saying is that the arbitrator might not be having all the tools necessary to come to a correct decision. Might not have is a different thing.
It
We do not know.
will not have, because the Arbitration Act does not provide for anything else except for a special.
Evidence. You give your evidence. Whether the evidence is sufficient or not, that can be seen.
Lordship, my submission to that effect is that.
No, I'm
yes,
asking,
yes.
I'm still on the fence. So I can fall this side of the fence or this side of the fence, so it depends.
To that, Lordship. Evidence should be here, Lordship, here, evidence now. To that effect, I would say if what evidence would be led in this case, again, we have to go to the merit here, if evidence has to be led. Here, there is no, as Lordship had said, that there is a flat which has not been delivered, but not delivered as to reasons, which are the reasons to it. Now whatever be the evidence, now fire department, now authority has the power, the adjudicating authority has the power to call for any department. They can call for the GMC also as to why this is not there. They can call the fire department as to why you have not given which the arbitrator, in my respectful submission, will not be able to call. Because the arbitrator talks about an arbitration, it only talks about appointing of a expert body. That too when both the parties agree. If both the parties don't agree, that's
Okay, in this case, you have appointed their arbitrator.
yes.
Lordship, yes.
They have not appointed.
And I think
Lordship,
he
a
was,
short rebuttal, Lordship, a short rebuttal to
and
the
he
point.
was prior to the thing, he was suggesting this aspect, I am not sure about it yet. He was suggesting single arbitrator.
Yeah, Lordship can appoint a single arbitrator.
That's what he was saying, but I said I
there was a
cannot
case with
comment
Supreme Court.
without the.
Lordship, there was a case in Supreme Court, Lordship, where there was an arbitral tribunal.
I was not aware of this. He had just told me that even though the agreement says
Lordship,
that
but
one
before
by
that,
him,
Lordship,
one by me, and one by the umpire, then even then only a single arbitrator can be appointed. To that, I will require instruction whether my client will be agreeable or not. That
No,
is
no, I'll have to see,
Lordship
let
can-
us
Lordship has
see
the
if
power
the
to
law,
serve.
if the law allows
to
then I-
change the arbitration agreement
to change that portion.
portion. That also I was not aware.
Then
He
If
just
if that is there,
uh,
then how does it matter if your client is agreeable or not? First of all, he's not going to be agreeable for the simple reason that you're not agreeable to arbitration.
yes.
So why?
No, to that point, I'll just need time to rebut because he has just told me. Because if the law says, I don't know whether he has just told me this thing.
Whether he's fabricated the law.
No, not fabrication. What is his interpretation of the thing? Maybe he
Let
has
us
just,
see if it's in black and white.
if it is black and white, that's okay.
Okay, what do you think of this proviso
Lordship,
to 18(1)(a)?
Of the right.
First you go to 18(1)(b) and then to the proviso.
If the promoter fails to complete or another.
He shall be liable on demand to the allottees in case of the allottee wishing to withdraw from the project without prejudice to any other remedy available.
This has to be read probably with 79. It is not.
So out here, he has got he can avail of some other remedy also without prejudice to any other remedy available. You see, 79 is different. 79 is bar on the civil code.
No,
That's a different-
it's lordship 88. Sorry, 88. 88 is furtherance. The provisions of this act shall be in addition to
And not in derogation
Derogation.
of, the provisions of any other law for the time being.
probably both has to be harmoniously that's what.
So, no, but you see, for one, what the petitioner trying to say is that already there is an arbitration clause in the agreement executed between the parties. Knowing fully well that the RERA Act would also have a bearing in this case. Because that is the purpose for which it was made from the very beginning.
These are undisputed facts. It was the agreement was signed after the enforcement of this act. There is no dispute.
So,
my submission-
when you look at it that way, this entire, the disputes could have in any event been decided under the RERA Act.
Yes.
Knowing that, you still made a arbitration clause. Yes, where is your,
Lordship, just one rebuttal to the. point
The
that-
judgment.
where is your single arbitrator?
Judgment. Here,
So Lordship, in this case, This is international judgment, Lordship, being dealt by the Supreme Court. So similarly, Lordship, in the arbitration clause, there was the arbitral tribunal was to consist of three arbitrators. But Lordship, after deciding that the respondent has chosen to contest with the case, thereafter the Honorable Supreme Court held appointed just one arbitrator.
Party's name?
Uh,
Party's name is MS Azim Company Limited. Arif Azim,
Arif Azim.
ARIF AZIM. Company Limited versus MS Aptech Limited, APTECH.
That's 21, for the person is at, page 57, para 92.
Maybe, but then Supreme Court has got all the power in the world to do anything it wants. I don't know.
Lordship also has the power. Lordship has got the panel of arbitrators. If my learned friend agrees, he can
If you,
A single arbitrator.
single arbitrator.
Whether the power, Lordship was,
Lordship has the
what
power
is,
if-
what
my query
query
was,
was different.
Lordship.
my query was whether I had the power
Yes, Lordship, that is
to limit the number of arbitrators to one.
In my
beyond
opinion,
the
Lordship, there is the
agreement.
power.
Beyond-
Because
beyond the
beyond
Your Lordship, 11(6) is a concurrent jurisdiction. When it comes to international arbitration, it goes to Supreme Court. When it comes to domestic arbitration, it comes to the High Court.
I'm
Lordship,
not
the
on that.
powers are-
I'm not on that. I'm on the issue of when there is an arbitration clause,
Lordship.
providing that an arbitral tribunal shall consist of 3 arbitrators.
Lordship.
Can this court
under,
limit that to one?
Can, Lordship.
under section 11,
In my
under-
opinion, it can, Lordship. Because
under,
that
it's
is
not
what-
under 226.
No, no.
Yeah, with the consent of the parties, naturally it can be done.
Lordship.
But are they
If my
going to give
learned-
consent?
Senior agrees.
Are they going to give consent when
No, they might-
when he says that we should go for, you should go for under the RERA
Lordship,
Act?
we-
In case your lordship decides to appoint the arbitrator, then I can take your instruction regarding that consent, because that would be a different aspect altogether, because I do not know, they might take, they might consent, that I cannot give.
Prima facie, I'm thinking of appointing an arbitrator.
So if lordship,
So if I appoint one, it'll be for you. And which means that the two of
Lordship,
you all will
I
have
have
to
my
appoint
consent.
another one. So
Lordship, I have a consent if Lordship can appoint a single arbitrator.
the cost factor.
is,
You are, remember, he's going to have a problem, you are also going to have a problem.
not that, primarily lordship, because of the cost factor only, I'm saying that I'll have to take us, and
Now, when can you come back?
lordship, it's a company, I will need at least 1 day's time, because they have to consult with their top bosses.
So
So,
I'm very, I've got time constraints. I'm not going to sit here next week. There's some things that has to be done in Mangala.
yeah,
So I will not be here.
next,
So if you can come tomorrow, that's all.
if lordship allows, I just take a, if I can take
We can sit at 2 also. No problem.
2 full benches there. That's,
Okay, you can come before 2 to my chamber, both of you around 5 to 2. So I've got a meeting. Anyway, you can wait for me outside the corridor. You just have to say yes or no. That's all. You don't have to come to court.
I'll just inform,
Yes, you
I'll
just have
just
to inform anytime. You can inform me during the course of the day also. Then depending upon if it's possible, then if you take more time, then of course, then have to go to the end of the month.
I'll just inquire, because it's a limited company, their directors have to give consent. That's the difficulty, nothing else. Had it been some private limited company, then
RERA would be more of a problem. Of course, there are a lot of appeal provisions.
we are on the thing, because the RERA, there are other pending cases also is there, and it's already going on regarding this aspect.
Prima facie, I'm of the view that arbitration
Yes.
is the only way out. I mean, it's not the only way out.
It's
It
the
is-
alternative.
Yes, there's an alternative remedy which can be available.
My submission is also maybe.
Yes, everything will be recorded. Only thing is that, you see, why I want this is, I'll have to make it CAV.
Lordship.
because I won't have time to complete.
The Lordship, then may I suggest Lordship? Lordship may make it CAB regarding the appointment of arbitrator, if it is single, so that can be left open. Upon,
Then
the
I cannot leave it CV that way. That is an incomplete.
Lordship, then I'll just inform during the day of.
Find out if possible,
If
if not,
possible, otherwise.
yeah, otherwise we'll fix another date
Fix and-
for that.
I'll just
for-
inform within.
For that would, if you're not unable to get your, if you're unable to get your, query answered, you might have to fix another date though, on the next date.
It will be only to that extent,
Only to
otherwise,
that.
all has been
Yes,
argued both sides.
everything, nothing is.
Nothing.
So this, these, notes and all made, what is these notes? Spell gave me.
Lordship, this was a written argument that I had.
Why are you giving me all this? I didn't ask you for this. You see, when you give us, you add more, you know, you add a lot of more homework to our already full docket of cases. I don't need I just need the judgment. Envelope there. Not the, acha, we'll have to adjust, we'll have to, you just send it to my team. So, okay, if the only problem is supposing he said that he needs more time to obtain instructions, that is my only problem.
Lordship, then keep it as a part had matter.
Lordship, to be on the safe side, let it come after Lordship returns,
That'll be after 2 weeks.
2 weeks.
Or Lordship can also keep it as a part. I don't know.
After 2 weeks, a date may be fixed, and to that, only to
Okay,
that
I
point,
heard
I'll.
Mr. Sir. This is the matter as partner, but you can, if you can give me now, then,
If I can give,
I don't want to keep, you see, I've got quite a few matters already with me. Yes. I'll be back then. I'll be back on 27. No. Maybe 28 or, this is about 20.
yes,
And this is a matter of partner. Partner,
deeply obliged.
but if you give it me now, you give now,
Hmm.
the information, then I'll release it, I'll say CAV.
I just,
Or leave it partnered, how does it work? Partnered that, on that day we'll pass the judgment. Oh, there's some other. Yes.
Item 7.
May please, your lordship.
What does this matter?
Lordship, I have challenged the order passed by the railway authority. Lordship directed me to pay rupees 9,58,000 lordship as a maintenance charge of their railway crossing, lordship. I am petitioner is the college, lordship. Lordship, kindly pay with annexa for page 25.
Page,
25, lordship.
have you filed any affidavit?
No, lordship.
No,
You are not filing.
no, we are not filing. We'll rely on this only. The only is a question of law. Let her.
Finish. The question is, who is to pay for the,
Yes,
Yes.
what that crossing?
maintenance of
Level
the railway
crossing.
crossing.
Page 25,
25, lordship.
yes,
This is the letter issued by the railway authority to the principal, lordship.
yeah.
You may be aware that level crossing are one of the major safety hazard concerning the railway. Therefore, railway have taken initiative for elimination of railway crossing either by providing ROB RUB on first hearing basis depending upon the feasibility or by closure of gates. In turn with this policy, Tinsukia division has also conducted an exhaustive survey of all the level crossing gates and identified gates which are catering exclusively to defense, state government office, PSU and private entities. Level crossing gate number so and so in such gate which is catering exclusively to the requirement of your organization and the railway on its part is incurring substantial amount in maintenance and upkeep of the level crossing gate up to the required safety standard. In view of the above, the maintenance chair and level crossing gate have been worked out to the turn of rupees 9,58,370 for the financial year 2017 and 18. Therefore, it is requested kindly to pay rupees so and so of the undersigned in the shape of demand draft of so and so as maintenance charge. Then, Lordship, I have replied of this note letter, Lordship. Then they have issued another order, Lordship, page 27. Annex 6, Lordship. I have replied. My reply is the next page, Lordship, page 26, Lordship. We are surprised to get above mentioned letter on so and so that we do not understand how we come to the picture. Don Bosco College, Golaghat was started in the year 2015 only, but the manned railway crossing was existing much before that. However, regarding the above mentioned subject, we would like to make the following observation. Don Bosco Society is engaged in the propagation of education and upliftment of the poorer people of the society. As such, we purchase land all over the Northeast, the rest of the country and in 132 countries of the world. The land at Golaghat was purchased.
Yes, yes. What is your case?
Well,
Section 16, Lordship, of the Railway Act, Lordship. Please. I have quoted, Lordship.
Where? Para?
Paragraph 8, Lordship. Page 7, Lordship. 16, Lordship.
Yeah.
Accommodation work. A railway administration shall make and maintain the following works for the accommodation of the owners and occupier of the land adjacent the railway, namely such crossing, bridge, culvert, and passages over, under, or by the side or leading or to or from the railway as may be in opinion of the government to be necessary for the purpose of making goods and interruptions caused by the railway to the use of the land through which the railway is made. So under section 16, Lordship, Railway Authority has to maintain, Lordship, their railway crossing. And in fact, that notice was issued, Lordship, without any Lordship, that a letter was issued, Lordship, without issuing any notice to the petitioner, Lordship.
No, how, where is the issue of them paying anything?
my lord,
If any accident happens, railways will pay.
no. Lordship may have a look at section 19 of the Railways Act. It is not there in Railway Act.
Where is section 19?
It is not there in the writ petition. I'm just referring from the statute. May I read, madam?
Yeah.
Overbridges and
I can
underbridges.
provide, Lordship.
Wherever a railway administration has constructed lines of rails across a public road. Now, here is a case where the rail line crosses the road leading to the institute. So it's a road. So Lordship may have a look at section 19.
Yeah.
Where a railway administration has constructed lines of rails across a public road at the same level, the state government or the local authority maintaining the road may at any time in the interest of public safety require the railway administration to take the road either under or over the railway lines by means of a bridge or arch with convenient ascents and descents and other convenient approaches instead of crossing the road on the level, or to execute such other work as may be in the circumstance of the case appear to the state government or the local authority. Now, 2, the railway administration may require the state authority, government or the local authority as the case may be as a condition of executing any work under subsection 1 to undertake to pay the whole of the cost of the work and the expenses of maintaining the works. Now, the situation is like this, my lord. A railway line crosses the road leading to the institution. Now, keeping in mind the safety of people, railway has worked out and carried out a survey to find out which are the level crossings which needs to be maintained or stopped, closed. Now, if your lordship comes to the letter of 18/9/2017 at page 27, it says that
the railway administration has examined and found that they have taken a decision, a policy decision to reduce the level crossings and the rail gates, keeping in mind the safety of passengers and people. So the rail gates, which they feel are not required or which are catering the need of only individuals, they have decided to close down or to make a ROB or a ROB at the cost to be borne by the authorities.
But they are not an authority.
They are not an authority.
Then
So, may I pray, my lord, in this case, let their representation be sent back for a reconsideration by the railway. And if required, they can approach the state also, because this is a road.
it is nothing for the state. They do.
No, my
it is
lord, under
you.
section 19, it is the state, my lord.
Correct. You go and talk to the state.
No. That road
There-
is, no, that railway line, any road crossing the railway line, then in that case, if that no ROP or ROB is,
Look, Mr. Council, that road was there. Prior, that road and the rail tracks were there prior to construction of their
Yes.
building.
and it is catering, it is serving the need of that institution only. So if the railway,
So-
either they will have to pay the money or railway
No,
will
no,
be
no,
in a
nothing,
position to,
nothing doing.
my lord,
You have got no case.
no, my lord, lordship will,
No case.
lordship will bear with me for a second, my lord. This railway track crosses the road. Now there is a rail gate.
You don't want to put the railway gate, you take it out if
Yes.
you feel, you
You-
take it out. If any accident happens from,
No,
there-
we will
all the,
close-
all
no,
the
no, no, my
costs
lord.
you'll have to pay now.
We'll not take it out, we'll close that gate.
Why
that-
should you close the gate? How can you just close the gate? How can the, how, what about
In
the
that
school?
case, my lord, if section 19 comes,
No,
if in lordship, once again, lordship will see section 19.
no case.
Section 19 says, where railway administration has constructed lines or rails across the public road. So
Correct.
if a railway track is
it is for-
constructed over a public road, and if that public road is required to be maintained, then either the road has to be taken above the line or below the line.
Correct.
And in doing that,
And it is to be done by whom?
by the railways at the cost of the state government.
Then go to the state government. Why are you going to the
No,
school?
no, if in that case, my lord, if the state government doesn't bear the cost, then we'll be,
You do whatever we'll take, we'll see what happens to you. You try and do, we'll see what you do. You cannot do like this, just like that.
otherwise, my-
You've got a public function, you're the government, you're a part of the government, aren't you?
yes, we are,
Or are you a businessman?
no, my lord.
True and true.
It's
You are a
only
part of
one
the
gate, which is one gate catering the need of an institution, my lord.
So what? Maybe 100 gates, maybe one gate.
No, lordship, it is also other public are also using that, lordship. I have made categorical statement, lordship, that are not denied by the respondent, lordship.
So it is a public road. Now, if the rail line under section 19, if the rail line crosses a public road, and if the road has to be maintained, then it has to be maintained either by way of an ROB or an RUB, road
Mr.
overbridge
Council,
or
First
road
of all,
underbridge.
this is a public road. According to you, it has to be that construction has to be made by the state government or the authority
No,
Or by
constructed by the railways at the
whether-
cost of the.
at the
state
cost of the state
State.
government or the authority. Have you gone to the state government and spoken to them?
government. No, they
Have
have
you
also
gone-
not gone to the state
Why should
government.
they go? It is your duty to go. They are not an authority. Are they an authority? Are they an authority?
My
Are
lord,
they the state government?
No, my lord.
Hmm.
They are not the authority. We are also not the authority to decide whether the ROB has to be constructed or not. It is if the road is to be used by them and that requirement of an ROB is there, then the ROB it is the state government. They should approach the state
They are the
government.
government. For the people, of the people, by the people, for the people, what? All that. What is that for?
Because
It is only for you.
it is the railway administration.
Look, Mr. Council, prior to the construction of the school, the railway gate was there.
Yes.
Then?
Now, my lord.
Now, where is your
I-
case?
now-
I can
Now,
understand.
they have undertaken the survey keeping in mind the railway traffic that has increased over a period of time. So
Then
number of
then
trains-
you please go to the government and to the state and to the authority concerned and tell them, because of this traffic, we now need to construct a road under or above in terms of rule 19, section 19, and please pay the cost. That nothing to do with the private institution.
And if the state government decides not to pay,
Then you do something, then you can go to the
in
next
that
level.
case, Lordship may
No,
observe
I'm
that.
not.
No, in that case, Lordship may observe that they will be at liberty to take up this issue with the state government
Ah.
for construction.
I will not say, I'll say that the law says it. I will
No,
not
with
take
that
up.
liberty that the railway authorities will be at liberty to, otherwise, my lord, the state government will not respond. And my lord, this,
But then, Mr. Council, it's like this. Because though, just because the state government will not respond, you're taking out your issue or your problem with a private body who has got nothing to do with it.
yes, my lord, they are the end users, my lord.
So what?
Ultimately,
Everybody's the end. Aren't you the end user of a road?
yes,
Aren't you the end user of everything that the government got? You see, the government has to provide for everyone. It is not that it does not mean that it has to provide for only a certain section of people or the majority. It has to provide for the last person in India also.
yes, my lord.
You know,
But
that is the role of the
while
government for
doing so,
each
my
and every one.
My lord, while doing so,
It's
the
not the
railway
way.
administration will also have to take care of their own properties and all.
As per
So
the
you-
law, as per the law.
Yes, my lord.
That's all as per the law, nothing else.
And the lordship will record that section 19
I will
with that
record it.
situation.
Because you can go there.
And railway administration can take up this matter.
You
That-
take up, you want to take up, you don't want to take up, that's your prerogative. The law is there. Why should I, I'm not an administrator.
No, my lord, definitely your lordship is not the administrator. Just
Poor-
my lord, my lord, just to solve the problem of all.
No.
Ultimately, my lord,
But
ultimately,
you see, first of all, you have not given any document to this court. You have not filed any affidavit.
no, my lord. Even the affidavit.
No.
My
To-
lord,
to-
the affidavit
show-
will only.
To show
take-
that you have approached the state government in the
No,
first place.
that lordship can take, railway administration has not approached the state.
Then what would you
But the
want?
thing is, my lord, the decision was taken keeping in mind,
It is unfortunate. Why shouldn't I impose cost upon you?
my lord.
Why shouldn't I impose cost upon you? Upon the railways? For making this poor petitioner to come here. This is not done.
Is the safety,
Safety, all right, but the safety aspect as per the law that you have just read out is to be borne by the state government and the authority, not by them.
exactly. If at all the. road has to
Then
be
you tell
maintained.
everyone in Guwahati to make gates in front of their buildings so that no one comes in. Tell them not to make roads. Don't tell them not to do this. That if you make more roads, then there'll be more traffic. People will get hurt. Can you do this? What kind of a, who is this person who has given such an order? Divisional engineer.
No, he is
Right.
the divisional engineer.
Right. Oh, meeting. I've got a meeting. Okay. Third, Miss
P. Bhattacharya.
P. Bhattacharya, learned counsel for the petitioners, and Mr.
S. Chakrabarti.
S. Chakrabarti for the for all the respondents.
Yes, my lord, railway.
Railways. Hearing concluded, judgment reserved. I've got no time. I've got a meeting.
Okay.
This section 16 and 6.
19.
I will see the book. 60 and 90. Any more matters? Any more matter? One more. Yes. Item 9. Yes. What is your case?
It is about the industrial dispute that, sorry, I left the. file
Transfer matter.
Industrial dispute also.
We'll adjourn no time now. Because of-
Any day maybe fixed,
I'll release the matter next week. Next week.
like any.
list the matter, any date, give a date. Huh?
What's it?
I think today it's my turn to start.
Maybe.
Or rather, your turn to close.
We have nothing more to say. We have, our part is over. Yes, yes.
May it be the last. My lord, what I propose to do, first I will refer to the repetition, then to the judgment, then to the scope of review, and 3-4 judgments. That's all. I'll take about half an hour of program. My lord will first take the amended repetition filed before the learned single bench, which eventually was referred to my lord larger bench. You'll also to kindly have the file of the learned single judge. I think it should be page 177, my lord.
There,
That the petitioners beg to state that service of the member of petitioner association for rendering services as Shiksha Mitra for long tenure in terms of the statute is mandated to be continued even after the 10th plan period, inasmuch as similar scheme as introduced in other states like Karnataka, Tamil Nadu, West Bengal, Tripura, etc., is to be formulated in the state of Assam also.
no, you are reading where?
My lord, amended petition
Amended
learned before the learned single judge, para 7B, capital G,
para 7, okay,
7B, my lord.
7B,
I think it should be page 182.
182, correct.
Yes. That the petitioners beg to state that service of the member of the petitioner association for rendering services as Shiksha Sarathis for a long tenure in terms of the statute is mandated to be continued even after the 10th plan period, inasmuch as similar scheme as introduced in other states like so and so is to be formulated in the state of Assam also. It is stated that state respondents, despite extracting service from the Shiksha Sarathis, have even failed to pay their remuneration regularly, whereas attempts are being made to replace them by another set of persons, taking the period contractual appointment with artificial break of 11 months. The petitioners beg to state that all the procedure and process of selection are being followed while engaging the Shiksha Sarathis under the SSA like that of a regular appointment. It is stated that
Which is the internal paragraph
7C, my lord.
of the amended petition?
Yes.
Not petition, not petition. Oh. Yes, we have an internal paragraph. 7, 183.
Internal page 7, my lord.
Yes, internal page.
Yes.
7C.
Yes. That the petitioners beg to state that all the procedure and process of selection are being followed while engaging the Shiksha Sarathis under the SSA like that of a regular appointment. It is stated that even in the statute of the SSA, there is no single whisper regarding engagement on contractual basis. However, respondent authorities in total deviation of mandate of the statute have introduced the contractual appointment for a period of 11 months, even though the scheme is continuing for the last more than 10 years. Then 7D, that the petitioners beg to submit that apart from providing training to Shiksha Sarathis under diet, the state government on repeated demand from SSA workers have very recently decided to afford opportunity to various groups of teachers under the scheme, namely Shiksha Mitra, Shiksha Saruthi Community Volunteers, Jyoti Kendra and Shiksha Karmi. In this regard, it is stated that on 23/3/2013, a special TET was held for Shiksha Mitras and services of teachers have been regularized. Again, on 9/8/14, an advertisement has been issued for the second special TET for Shiksha Mitras, the process of which is going on. That the petitioner state that this honorable court in WPC number so-and-so, miss case number so-and-so in WPC, made some observation, and whereupon the state government, apart from holding special TET, has issued instruction to all concerned authorities to submit detailed particulars of Shiksha Sarathis, Shikshas, Karmi, volunteer, Sahayak, block resource person, district quality manager, Shiksha Karmi, education volunteer, etc., engaged under the SSS scheme. The petitioner state that Shiksha Sarathis being identically situated deserve similar consideration in the hand of the respondent authorities. Now, my lord, what the petitioners highlighted before the learned single judge, which was eventually referred to larger bench, was, my lord, that under the scheme of SSA, there is no provision of making contractual appointment. Yet they were appointed. Secondly, my lord, Shiksha Mitras were similarly situated like that of the members of the petitioner association, my lord. They were afforded to appear in TET, they passed TET and they were appointed regularly. Then, my lord, this para 7E, we have mentioned the judgments where orders were passed for extending them the similar benefit. So this is the background, my lord.
Was there any advertisement?
Yes, paragraph 10, my lord. One second. Yes, my lord, internal page 15, 191. That it should be petitioners beg to state that thereafter advertisement was made in newspaper for filling up the post of Shiksha Sarathis on the terms and conditions set for above. The petitioners had duly applied for the post of Shiksha Sarathis, and on being found eligible, they were all selected by selection committee. They have been appointed on merit basis against one teacher school as Shiksha Sarathi, for which they had to sign a contract agreement with school management for engagement for a period of 11 months. However, although the agreements were signed on 11/3/04, virtually their engagement continued up to 2010. And even as on date, the petitioners are continuing to render service. Then, my lord, will kindly come to para 14, internal page 70, that is page 193. We never said, my lord, that we rendered for more than service. What we have rendered, we have said that the petitioners beg to state, since the petitioners are continuing for last 7-8 years and have undergone training and acquired necessary experience, as stated earlier, state government is well aware of the policy of the central government that SSA is a continuous process. Thus, the state government cannot discontinue the service of the existing Shiksha Sarathis and replace them by another set of persons taking plea of contractual appointment with artificial break after 11 months, and instead may frame a scheme for regularization as has been provided in the statute of SSA, like other states as cited above, which stated that such artificial break has completely been discarded by the apex court in various cases. So these are the factual background, my lord, which we laid in our petition. Now, my lords, will kindly come to the impugned judgment. In the review petition.
No, Mr. Chaudhary, just a moment.
Yes.
If you'll come to internal page 62, annexure 4
1 second. Of the
amended date petition,
page 62.
62,
Yes.
internal page, annexure 4.
Yes.
last paragraph, it says you are aware that all these single teacher schools are required to be provided with one Shiksha Sarathi during this year. So that means they are limiting
Yes,
it.
my lord, there is no dispute that we worked up to 2006-7. Thereafter, we are engaged in different capacities in the same space. That's why we said, my lord, 7-8 years. In paragraph 14, our clear case is that on the day when we approached the court, we had the experience of 7-8 years. Now, in the judgment, my lord, something is that that's a wrong evaluation of the fact. That will not give furnish a cause of action for a review. And I'll come to that, my lord. Now, my lords will kindly come to the review petition at page 27. Page 27, para 15. On the other hand, Sri Mr. P.N. Goswami, learned standing counsel SSA has raised twofold objection to the prayer made by the petitioners. First objection relates to res judicata, in respect of which he submits that earlier division bench decision in Arup Kumar Bhuya has finally decided the issue raised by the petitioner, and the same cannot be reopened again. Secondly, on the issue of regularization, he submits that appointment of the petitioners were contractual in nature for 11 months, which they had accepted. Therefore, petitioners cannot seek regularization of their service. In this connection, he has placed the following. So substantially, what the state is arguing before lordships, it was argued by the council, my lord. He says that since the appointment is in contractual basis for 11 months, therefore you can't do. Your claim for regularization is not justified. In spite of that, a judgment is rendered. That could be a wrong judgment. Is that to be corrected in review jurisdiction? Now, my lords will kindly come to the impugned judgment at page 43. Para 42. Reverting back to the case of the Shiksha Sarathi, we find that notwithstanding their initial engagement for 11 months, their engagements have continued for more than a decade now. As a matter of fact, their engagement is now in the second decade, which clearly indicates the necessity and utility of Shiksha Sarathis as assistant to the teachers. But this view of the full bench could be a wrong view. But it is premised on the basis that SSA is a continuous scheme. It is not even after 10 plan period, it was supposed to go on. And the fact that we have worked for some period of time. And our entry into service was by following some process of time. It was on that background, my lord, the final expression finds place in para 42.
Mr. Chaudhary, this may be a question of fact, but don't you think that is an error apparent on the face?
No, my lord.
When you have sat in pleading 7
Yes.
to 8 years,
Yeah.
court assuming that you have continued for 2 decades,
Yes.
isn't it an error apparent on the face?
No, my lord. Question is
You-
whether that
You
they
have
have-
contended that erroneous judgment per se may not be a subject matter of review.
yes.
But that error, whether it's an error after deep introspection, or is it an error which is apparent from the face?
No, my lord, let me place it. That's why I said, my lord, while drawing the conclusion as we find in para 42,
Yes.
the Honorable Court had in mind several factors. What were the factors? That SSA is not coming to an end, that it is a continuous thing. It is likely to continue beyond. We also made submissions that similarly situated Shiksha Mitras who were given TEP training, they passed, they were regularized. We say that we have served for more than 7-8 years. Then, my lord, that we have an expectation And secondly, my lord, most importantly, this process of appointment, it has evolved by a process. Therefore, recognizing those things, my lord, this paragraph was there. Yes, there is a mistake apparently. As a matter of fact, is now in the second decade, that is apparently wrong. Now the question is, my lord, why this wrong can be corrected only by review? It can't be corrected by an appeal? My lord, in my humble submission, there is a distinction between appeal and review, and lordship must recognize that distinction. Otherwise, my lord, it will obliterate. My lord, why can't, if state can prefer a review, why can't state prefer an SLP? My lord, review is not an substituted remedy. It's a remedy. As my lord, the substantive power of review flows from section 114 of the Civil Procedure Code, and the procedure is laid down in Order 47 Rule 1A. And my lord, in the context of 226, the Honorable Supreme Court has laid down the contours. Now, my lord, let us take the state's case. Now they say, while they're trying to implement the judgment, they could notice that we have not put in 10 years. Therefore, they filed the review. If we have not, put in 10 years of service, what prevented the state from filing an SLP? That the High Court was wrong. They have not served for 10 years. They have served for 6-7 years. But my lord, there is no stipulation in the judgment that in order to get the benefit, there has to be 10 years service. Where from that has come, my lord? The judgment does not contain any direction that only those who have completed 10 years of service, their case alone will be considered. Where is that, my lord? There's none. This Honorable Court was of the view that state was magnanimous enough in Utpal Das's case. They themselves came up with a proposal that will allow them to continue up to the age of superannuation. We'll give these benefits so and so, so and so, so and so. Court has extended this to us. Our appointment is not irregular. It was by following a due process of law. Now, where is the scope of review? Why review? Is there a justification that when we wanted to implement the judgment, we found they have not put it? Where is the stipulation that there is a requirement of 10 years? There's no requirement. It all depends upon the facts of each case. My lord, actually, contempt petition was filed, contempt was initiated, then they, my lord, did all this. Now, my lord, with all respect, I'll submit, my lord, this cannot be a case of review. It's not that there is an error apparent on the face of the records, number one. It's not that in spite of exercise of due diligence, certain relevant facts which had a bearing could not be brought to the notice of. My lord, at page 27, I have already read out. The stand of the state was, since the appointment was for a period of 11 months, they cannot be considered for regularization. What more is required, my lord? So in spite of that, a judgment is given. So it's an error. Now, it is not an error as we understand in the context of my lord review. It is an error what we understand in the context of appeal. Every error cannot be corrected by review jurisdiction, my lord, even if it is error apparent on the face of the records. Or else, that means, my lord, to appreciate that lordship will have is doing the re-hearing. That is not the scope of review. Therefore, my lord, my humble submission is I'll place few decisions on the scope of review. In fact, in the, my lord, affidavit in opposition, we have brought out that order. If your lordship would kindly have that page number, that additional in our initial affidavit, my lord, at page 12. On 15/6/2020, we file our initial affidavit, where amongst others, we also raise the issue of maintainability, delay, etc. Page 12.
In the review,
Yes, madam. In the first affidavit that we filed, Yes,
Made in June.
yes, my lord. Page 12 of that affidavit.
Page 12 is the order.
Yes, 7, 8, 19. It's an order passed in the contempt proceeding. Second para, having heard the learned counsel for the parties and on perusal of the materials available on record, we are of the considered opinion that contempt proceeding needs to be initiated against the respondent number one for the present. Hence, initiate contempt proceeding against respondent number one. Thereafter, my lord, this review petition was filed. And it was filed after a delay of more than 7, almost, my lord, 670 days. In this affidavit, my lord, we have raised that plea that it is barred by limitation number one, at least barred by latches. And secondly, my lord, we have also said that it's not a case of review. It's not a case which falls within the parameters of section 114, read with order 47 CPC. So, their basic case is that when they wanted to implement the order, they could notice that we have not put in, the required number of years. That is not a requirement under the judgment number one. And number two, my lord, at page 27, I have already indicated that was the stand of the state. And that is a stand which is duly noted in the judgment. That we have only served for 11 months, therefore we are not entitled to be considered for regularization. In spite of that, court passes an order.
So you served for 11 months
No, we served initially for 11 months.
and then for,
Uh,
for
On the
7
date when we approached, my lord, we served for about 7, 8 years. We have clearly stated in paragraph 10 of our petition.
as Shiksha Sarathis.
As Shiksha Sarathi and some other capacity also.
And on the date the order was passed by the full bench,
Yes,
some of you were still working
yes,
as Shiksha Sarathi.
yes. Not in Shiksha Sarathi, but in some other capacity, in the same school. Those certificates are annexed, my lord.
So when did you stop working as Shiksha Sarathi? All of you?
2006, 6, 7, that year.
You're stopped working. And you approached the court on,
We approached the court in 1 second, my lord. We approached the court in 2012.
on 3/10.
তিনটা judgment আছে petition. My lord, can I place the judgment? That 1979 4 SCC 389, para 3.
Yes.
1, 2, 3, 4, 5, 6, 7, 8. Line about 9 from top of para 3, my lord. It is true as observed by this court. Has your lordship got it? Yes. It is true as observed by this court in Sibdev Singh versus State of Punjab. There is nothing in Article 226 of the Constitution to preclude a High Court from exercising the power of review, which inheres in every court of plenary jurisdiction, to prevent miscarriage of justice or to correct grave and palpable errors committed by it. Now, I'll see. But there are definitive limits to the exercise of power of review. The power of review may be exercised on discovery of a new or important matter or evidence which, after exercise of due diligence, was not within the knowledge of the person seeking review or could not be produced by him at the time when the order was made by it. It may be exercised where some mistake or error apparent on the face of the record is found. It may be exercised on any analogous grounds, but it may not be exercised on the ground that decision was erroneous on merit. I am on this point. But it may not be exercised on the ground that the decision was erroneous on merit. That would be a province of a court of appeal. A power of review is not to be confused with appellate powers, which may enable an appellate court to correct all manner of errors committed by subordinate court. My lord, it is not a case that for the first time after the judgment they could come to know that situation which they would now like to project was already projected before the court, my lord. They say that they have only served for 11 months for a contractual period, therefore they cannot be regularized. That's why it is said, my lord, all errors are not to be corrected in a review jurisdiction. Which all are the errors which are clearly indicated in Order 47, Rule 1N. Therefore, my humble submission is, my lord, it is absolutely not a case of review. If at all the Honorable Court was wrong, my lord, that is a wrong which can be taken care of only in a review jurisdiction. And nothing prevents the mighty state of Assam, my lord, to move the Supreme Court. Then the other judgment, my lord. Nine. Please take this 2006 8 SCC 686 para 16. At page 692. The division bench of the High Court committed a serious error in entering into merit of the matter while exercising its review jurisdiction. The court jurisdiction to review its own judgment, as is well known, is limited. The High Court indisputably has power of review, but it must be exercised within the framework of Section 114, read with Order 47 of the Code of Civil Procedure. The High Court did not arrive at a finding that there exists an error on the face of the record. In fact, the High Court, despite noticing the argument advanced on behalf of Union of India that the first respondent had no legal right to be appointed, proceeded to opine that panel prepared for filling a future vacancy should be given effect to. A review of the High Court was not only contrary to the circular letter issued by the High Court, but also contrary to the general principles of law. My lord, in my humble submission, this is a judgment for the proposition that review power can be exercised only within the four corners of Section 114, Order 47, Rule 1N. And its power is very, very limited. None of this situation visualized by Order 47, Rule 1 and 2 is present in the instant case. Therefore, in my humble submission, the power of review cannot be attracted in this case.
Okay, one question.
Yes, Madam.
The, now it appears that the full bench, there was an error on facts as per para 42. Now, was the direction passed based on those error of facts? It was.
No, my lord. It is not that we also said something which is contrary to the records, or the respondent did not say anything. That is not the situation. The Honorable Court, my lord, perceived the thing wrongly. Now, can there be a ground of review? The Honorable Court, my lord,
But can't,
while taking note of the fact
Hmm.
that in fact we are in the second decade, that is wrong, absolutely wrong. That I am not saying yes. But that is the view which the court has taken. That's a wrong view. That wrong can be corrected by a court of appeal, not by a review court. That is my case. They are not remediless, my lord.
okay, no, so but so the subsequent question is,
Yes.
the direction was passed on the basis of that wrong
Yes.
view. That's-
Supposing, my lord, tomorrow if the Honorable Supreme Court finds that this finding is wrong, therefore consequential directions are also bad. That is for the Honorable Supreme Court to take account.
So there was no other, so it was not based on any other issue, only on that.
Yes. Well, I'll refer to two more judgments, my lord. I think we say now. 2008 8 SCC 612 recently. 2008 8 SCC 612. I'll refer to para 21 and 22, my lord. Uh, 2008 8 SCC 612.
What are the parties' names?
My lord, State of West Bengal versus Kamal Sengupta.
No, it's not here in the bunch.
It was an 2013 8 SCC 320.
These ones are all by the state, no?
13 we have.
Yes,
Kamlesh Verma.
Kamlesh Verma. On last occasion, I did place the judgment. Yes.
It has been quoted extensively in the subsequent judgment.
Yes, here it says, my lord, which are the situation where review should be exercised. It should not be. That is for you. Yes. My lord, these are the judgments. Now, basically, my lord, that Manipur case, that
wait,
Judicial
I don't
Commissioner
have-
judgment. In fact, on last occasion,
Kamlesh Verma, you're relying on which paragraph?
Kamlesh Verma, my lord,
Which paragraph?
paragraph 17, 18, 19, and 20 and 21. In fact, my lord, paragraph 20 lays down the principle where power of review should be exercised, where power of review should not be exercised.
And Adhikam has been considered.
Yes. Now, my lord, taking a cue from that Arimbam's case, my lord, where it says, province of review is not to correct an error of fact. Province of review is to, my lord, basically address a situation where certain relevant facts which have a bearing with, in spite of exercise of due diligence, it could not be brought to the notice of the court. It is in such situation or analogous situations, my lord, a review jurisdiction is envisaged. Otherwise, my lord, the legislative intention to provide both review and appeal does not stand to any logic. Because we all know the appellate provision is a very lengthy one. Review is a jurisdiction, my lord, where immediately it can be redressed. That's why it is said, my lord, the error must be of such a nature that it is self-evident. No detailed reasoning is required to find out what the review is. So, my lord, coming to the facts of the present case, state would like to say that we are actually not eligible for this direction. Basically, that is the case on account of XYZ reason. Therefore, the consequential direction given is wrong. It can't be a province of review, my lord. With all respect, I'll submit. With all humility at my command, I'll submit. It's a province of appeal. And my lord, how they explain this 670 days delay? If a judgment is wrong because facts were wrongly evaluated, it can't be a province of review.
But Mr. Chaudhary.
Yes, madam.
Last time, the Advocate General had submitted, had referred to the case of BCCI.
Yes.
BCCI has
That's
a
a new
remark.
fact.
No, it has a remark about misconception of fact.
No, my lord. Let me tell your lordship, I brought that judgment. What was that judgment, my lord? Certain undertakings were given to the court which turned out to be wrong. How can the principle of law laid down in that case will govern not generally the, my lord, review cases? It's a case where lordships will find from paragraph 82 to 93 that, my lord, wrong undertakings were given. It was in that context, my lord, this review jurisdiction was exercised. It can't be a proposition of law, applicable in all cases. In fact, if your lordship will kindly come to the judgment, even taste to the lordship. It's not the case that they have discovered a new fact. They say that we have not served for 10 years. So therefore, we are not eligible. An observation in a judgment naturally has to be understood in the context of the. Kindly come to para 87. Para 87 at page 764. Indisputably, an undertaking had been given by a learned senior counsel appearing on behalf of the board. In the interim order, the division bench before whom such undertaking had been given was of the opinion that it was misled. This court, having regard to the understanding of such undertaking by the division bench, does not intend to deal with the effect and purport thereof, as we are of the opinion that division bench of the Madras itself is competent thereof. The para 14 of the order of learned single judge to be taken into consideration. It is possible to contend that learned judge of the High Court were correct. Against the exercise of power of review, matter was brought, my lord. It was in this context, my lord, where certain undertakings were given, which ultimately turned out to be incorrect, or it cannot be acted upon. So, in my humble submission, my lord, a decision is an authority for what it actually decides. So, this cannot be a judgment applicable in all cases, my lord, that when new facts are brought in, a review jurisdiction would be available. Therefore, my humble submission is, my lord. Now, there is one more thing, my lord.
Mr. Chaudhary,
Yes.
can you revert back to paragraph 42
Of the,
of the judgment?
yes, yes,
Because we were revolving around the observation in
yes,
42.
yes, yes,
There is the aspect that there is no requirement as such for 10 years,
yes,
which you are trying to highlight.
yes,
Let us assume that this is the correct proposition.
yes,
There is no requirement of 10 years.
yes,
But the observation that the petitioners were continuing,
Hmm.
that observation, don't you think it's an observation which is apparent on the face of the record, is an erroneous observation? The certificates which you have enclosed
yes.
are certificates not as Shiksha Mitra or Shiksha Sarathi. Some are honorary teachers, some are voluntary something.
No, we said, my lord,
Where
when
is
we
the
approach the
continuation?
court, we have put in only 7-8 years of
That
service.
is exactly where we are. In spite of there being a method which is contrary to the observation,
Yes.
those observations, don't you think are absolutely on the face of the record erroneous?
No, my lord. Question
And-
is,
And when, which you are just repeating, 10 years requirement is not there.
yes,
5 years, 7 years, that is enough. But continuity in service And you're pleading that you are 7 and 8 years.
Yes.
Court, I don't know how he assumed 10.
Therefore, the honorable court was wrong. I am also assuming, my lord. Therefore, this observation is wrong on merit.
No, on that context, we are trying to
Yes.
get it from you. Error, an error apparent on the face.
Yes,
A mere error is a matter for correction before the appellate court,
yes.
within the domain of the appellate court. But when the error, what errors are to be considered the errors apparent on the face and
And,
what?
and lordship will consider it after 670 days.
That's a different aspect.
No, my lord.
That
Yes.
we have not even, you are free to advance your arguments, the aspect of latches.
My lord, my humble submission, or rather to respond to what has fallen from your lordships. I am very clear, my lord. Yes, it is wrong. But is it a wrong which is required to be corrected by review jurisdiction
That you have got.
or by, my lord, appellate jurisdiction? Then, my lord, the thin line of distinction which exists that obliterates. And that's why in Arambam's case said, my lord, such an error cannot be corrected in review jurisdiction because this is an error on merit. It's not that, my lord, some wrong facts were pleaded, then ordered. That is also a different situation. Here, correct facts were pleaded, but court took note of something which may be wrong.
This is an error on fact.
Eventually, yes, it is an error on facts, or rather on evaluation of facts. It is an error on evaluation of facts.
Whether there was any evaluation of fact.
No, my lord, it was in evaluation of facts. That's why this figure was arrived at, maybe erroneously. My lord, I am only trying to find out, possibly lordship will have to answer it, my lord. My humble submission is, there is a distinction, my lord. And that distinction has to be stand by. Otherwise, my lord, it will obliterate. Why, my lord, the legislature provided remedy of appeal and also remedy of review? The legislature could have said, all right, no appeal is required, review is enough. I think Arambam's case, Honorable Supreme Court has laid down the contour of review jurisdiction in absolute clear terms. If the case falls within that, certainly they are entitled to a relief. If it doesn't fall within that, they are not entitled to it. And they are not remediless. They can go to Supreme Court. And to see the circumstance. When we wanted to implement the order, we came to realize that no, they have not completed it. That is their basic understanding. That is nobody's case. Neither the Honorable bench which delivered the judgment proceeded on that, nor, my lord, it was our pleaded case. My lord, recently Supreme Court has delivered one judgment in the context of regularization. I'm sorry, it copy to 9 seconds. 2024 INSC 332 paisen ki? Now kindly see, my lord, para 5. This is basically nothing to do with review jurisdiction, my lord. This is on, my lord, basically reading down Uma Devi. But everybody says Uma Devi, no regularization, no regularization. Whether that is correct. Here is the judgment. Having heard the arguments of both sides, para 5, this court believes that the essence of employment and the rights thereof cannot be merely determined by initial terms of appointment when actual course of employment has evolved significantly over time. The continuous service of the appellant in the capacity of regular employees performing duties indistinguishable from those in permanent post and their selection through a process that mirrors that of a regular recruitment constitute a substantive departure from the temporary and specific nature of their initial engagement. My lord, Supreme Court came down heavily, my lord. Under the SSS scheme, there is no provision of appointing contractually, my lord. But people are offered contractual appointment. They have no bargaining power, my lord. What else do they do except it? They also, they discharge the functions of a teacher like regular teachers. So Supreme Court has taken note of this. I'm on the merits of the case, my lord, not on the other parts. So here, my lord, now, every time, my lord, state will come up, Umadevi is a bar. My lord, Umadevi is not a bar, my lord. In fact, Umadevi is a bar on the part of the court. The executive power to frame a scheme of regularization was never curtailed by my lord Umadevi. In fact, in Umadevi, many high courts were issuing directions for regularization. It was in that context it was. So now coming back to the facts of the present case, my humble submission is, my lord, even if there is an error, that error apparent on the face of the records is not an error apparent on the face of the record, as we understand in the context of review. If at all there is any error, that error can be corrected by an appeal, not by review. And my lord, this distinction as it exists in my humble submission needs to be recognized. That is my humble submission.
So one thing,
Of course, this was a case where they were working for 25 years.
okay, so this review has been occasioned due to the government not being able to implement the order. On what ground?
On the ground that they realize that they have stated in their affidavit, my lord. If your lordships will kindly take their affidavit explaining the delay, para 9 and 10, an appeal affidavit was filed on 3/11/22, my lord, where this purports to explain the delay. Para 9. Para 9. That since the direction to frame has a losses got it, my lord. Yes.
Para 9 of which affidavit? The review.
No, my lord, there is an
After-
affidavit filed by the state where they seek to explain the delay in preferring the appeal. It was filed, they served copy on us on 3/11. Para 9.
Relevant paragraph is 57. 15 of 57, 58.
That since the direction to frame.
Yes. That since the direction to frame a policy to extend the benefit given to master role workers and other similarly situated employees could not be granted to Shiksha Sarathi in view of the fact that none of the Shiksha Sarathi has completed 10 years of service as required. Therefore, the government has decided to file the appeal. So it is not that they have discovered a new fact, which in spite of exercise of due diligence, they could not, find it out. That argument was already there. That is only for a period of 11 months. So there's no question of regularization. So now, my lord, it is explicit. Neither the, my lord, honorable court took note of the fact that we have worked for 10 years. That is why the direction is.
Anything else?
I'm deeply obliged.
Yes. Mr. Saikya.
Actually, I should not have spoken, but we have to just see what was the original prayer. How the division of full bench proceeded in this case. The original prayer was also very clear at page. It will be in the continuous page 197.
Of the
Of the writ petition 5002.
190?
197.
Just a minute.
Mr. Chaudhary. Mr. Chaudhary is not. here. Okay,
Mr. Advocate General, you had made a substantive argument on our judgment of 17/11/2005.
Justice Gogoi's judgment.
Yes,
Yes, that has not been replied to.
that has not been.
You said that observation was made that it was discontinued. In the
In
judgment,
2005 itself,
2005, that was
those
somehow,
things have come up now when we wanted to
that
formulate
was
the,
not brought to the knowledge,
Yes.
notice of the court. That was your argument.
that was
It has to be
one of the
met.
main plan. I have two plans.
Yes, that was the
One
second
is
plan.
that Honorable Justice Gogoi's judgment that
Yes.
was never placed before the court. Number one, and number two, it is not about 10 years when we wanted to formulate that. We found that they were not working for last 12, 15 years. Forget about 10 years service, continuous service. They are not in service since 2006 onwards, when the judgment was delivered here.
And your formulation regarding application of RTE Act,
Yes,
it doesn't permit engagement of Shiksha Sarthi. That also has to be met.
yes. And a very recent judgment of 18th April, Supreme Court on review is very categorical on this
Name?
point. The judgment is State of Telangana versus Mohammed Abdul Qasim. Judgment was delivered on 18th of April 2024. 2024 SCC online, Supreme Court 548.
Then it over. 2000,
24 SCC online. Again SC, Supreme Court, 548. My Lord Justice Sundaresh and My Lord Justice Bhatti, State of Telangana versus Mohammed Abdul Qasim. Paragraph, it will be paragraph 24. All the general principles of review, Lordship will find that from section paragraph 15 onwards. What I am trying to place before the paragraph 24, where it starts with precedent, then error apparent on the face of record. In the judgment itself, the main lines are highlighted. It is well settled that the party is not entitled to seek a review of a judgment delivered by this court merely for the purpose of rehearing or a fresh decision of the case. The normal principle is that a judgment pronounced by the court is final, and departure from that principle is justified only when circumstances of a substantial and compelling character makes it necessary to do so. Several judgments are related there, given that. But whatever the nature of the proceedings, it is beyond dispute that the review proceedings cannot be equated with original hearing of the case, and the finality of the judgment delivered by the court will not be reconsidered except where a glaring omission or a patent mistake or like grave error has crept in earlier by judicial fallibility. Then several judgments are referred there. Such an error exists if two or more views are conversed, and on the point, it is possible to hold that the controversy can be said to admit only one of them. If the view adopted by the court in the original judgment is possible view, regard to what the record states, it is difficult to hold there is an error apparent on the face of record. Now, what are the different distinguishing factors? There is a clear distinction between erroneous decision and error apparent on the face of record. while the first can be corrected by the higher forum, the latter can only be corrected by exercise of review jurisdiction. That is, an error apparent on the face of record can be corrected only by review application, review jurisdiction. That is in within that same paragraph by referring to several other judgments. So these judgments have in a very convenient way have referred to all the judgments relating to various aspects of review. So this judgment, although in my earlier written arguments, I could not place because at that point of time, it was not known to us. Very recently, it has come to our notice and we have placed the judgment before the decision.
Recent discovery.
Recent discovery of the judgment.
Point
And here,
ground for review.
ground for, and subsequent development also, it has been very clearly says on subsequent development. On subsequent development, it has to be very much relevant. Discovery of new matter of evidence. That is the single judge's judgment of 2005. In that case, the Honorable Supreme Court says, by referring to not BCCI, there is another judgment which we have never placed. State of West Bengal versus Kamal Sengupta, 2008, 8 SCC 615. That particular aspect which will be placed before the court at the review jurisdiction, it must have some relevance. Subsequent development itself is not sufficient, but it should be subsequent development which must have some relevance. So if we look at the judgment under review, what is the final direction? The final direction at page is in my review application, it is page 45, paragraph 44.
Just a moment, I'm interrupting you. Please come to the judgment you have cited, this
Yes.
SCC online,
Recent one.
paragraph 20.
Paragraph 20, yes. Mistake or error apparent, that one.
Yes.
Mistake or error apparent on the face of record would debar the court from acting as an appellate court in disguise by indulging in a rehearing. A decision, however erroneous, can never be a factor for review, but only can be corrected in appeal. Such a mistake or error should be self-evident on the face of record. The error should be grave enough to be identified with mere cursory look, and an omission and glaring. It requires interference in the form of review. Being a creature of the statute, there is absolutely no room for fresh hearing. The court has got no role to involve itself in the process of adjudicating for a second time. Instead, it has to merely examine the existence of a apparent mistake of error. Even when two views are possible, the court shall not indulge itself by going into the merit. No quarrel on this principle. That is the principle which is general in nature.
Yes, anything else?
Yes, the paragraph 21 makes it very clear, the subsequent paragraph.
Yes.
So now certain things are admitted by the other side. That they are not working since 2006. This has fallen this morning as Shiksha Mitra. They were working as honorary teachers or various other posts which we do not find in the service jurisprudence so far as service Shiksha is concerned. Some schools, some principals may have indulged them as voluntary teachers. All those terminologies they have invented. So those are not relevant. And from 2005 onwards, they are not working in terms of the judgment of this honorable court. That has not been responded to also. Now, if we look at the judgment, the paragraph 44 of the judgment under review, what it has finally said? Therefore, having regard to the grievance expressed by the petitioners and the discussion made above, that means paragraph 42 also, that they are working for the second decade. We are of the view that it would meet the ends of justice is similar benefit as granted to master role, work charge, and similarly placed employees. What was given there in Upenda's case? Those are working for more than 20 years, 25 years, and continuing. And they want regularization. In that case, we told the honorable court that it cannot be granted. However, we are going to give them service security till the age of superannuation, that is 60 years, with some additional benefits. So this honorable court, the full bench said that similar benefits as granted to master role workers, work charge workers, and similarly placed employees working since last more than 10 years. Since last more than 10 years from 2000, the date of judgment. Not sanctioned, not in is extended to the Shiksha Sarati. So that benefit has been granted. So now, even if we do not file this review application, no contempt will lie upon us. Because when we have done the exercise to formulate a new policy, it has come to our knowledge that they have left their job as Shiksha Saratis in 2006. They were working in some clandestine post up to 2009, which they have admitted. So we have nothing to do. It will be a futile exercise at the end of the day. But in spite of that, when there is a glaring error in the judgment is apparent to us, because we wanted, our intention was positive, that let us formulate something to give some benefits to these gentlemen. But when we wanted to formulate that policy, it has come to our knowledge that they are not working for last 16 years. So what should we do? They are trying to impose the jurisdiction of contempt court. That will not put us into a contemptuous exercise, Lordship. We cannot be whole, or we cannot be hauled up for contempt. For the simple reason that this judgment is very clear that those who are working for last 10 years since the date of judgment or till the judgment was delivered, we have to give them some benefits, like the muster roll workers, work charge workers, or other similarly placed employees. So they are not there. It is not to evade contempt we are filing the review applications. We have filed a review application when we found that there is a glaring error, an apparent error, a manifest error, which is apparent from the record. And therefore, this the BCCI's case, paragraph 90 very clearly says, paragraph 90 says, thus a mistake on the part of the court, which should include a mistake in the nature of undertaking. That is one part also, but other mistakes also. Thus a mistake on the part of the court, which should include a mistake in the nature of undertaking, may also call for a review of the order. So when paragraph 40,
Which judgment? Huh?
2005 for SCC page 741. Now they are also admitting that that is paragraph 14 is mistake. The other side is also saying the same thing. They have repeated 3 times today that it was a mistake. And for that, I don't have to make any arguments also. No long drawn argument is required to impress upon this court that paragraph 42 was a mistake. In fact, there was no evaluation regarding the continuity of their service.
Anything else, Mr.?
And the last line of the judgment, accordingly, we direct the state to consider framing a scheme for Shiksha Mitras on the above lines, which decision shall be taken within a period of 6 weeks. So we have to frame a policy in the same line of master roll workers on the principle that they are working for last 10 years till the date of judgment. So in any case, it cannot be implementable now, this judgment. So our endeavor is that to place the correct facts before this honorable court. If this honorable court feels it's necessary, Lordship may be pleased to grant us and allow the review application by setting aside that judgment on because that paragraph 42 is apparently incorrect. And the subsequent follow-up direction at paragraph 42 it does not call for.
Mr. Chaudhary, just one question.
Yes.
This page 50 of the review petition. This is the judgment, the order passed by Justice Ranjan Gogoi. Now, out here, he says that there are no,
Similarly placed persons were not given release. A single judge of the High Court, a full bench of the High Court is given.
no, what I'm saying is, out here it already said that the period of, that no one was working anymore as a Shiksha Bharati
My
in
lord, these are
2005.
all in the realm of merit. My lord, please come
No,
to
no, I-
para.
I-
No,
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 no.
my lord, what was the relief given?
Huh.
We are not seeking, court has not granted regularization. Let us not go into that, my lord. Please come to para 39. The full court has taken note of everything. Please come to para 39 of the judgment. This is the last para I'll read, my lord. And of course, para 20 of the judgment, which my learned friend has referred, I think that supports us wholeheartedly. Para 39.
Yes.
We have already examined the nature of appointment of Shiksha Sarathis. Shiksha Sarathis are not teachers. They act as assistant to the single teacher in the schools, managed by a single teacher. For appointment of teachers in primary schools, we have the Assam Elementary Education Provincialization Rule, framed in exercise of the power conferred by proviso to Article 309 of the Constitution of India. Conditions of recruitment of assistant teachers, constitution of selection committee, procedure for selection and appointment, etc., have all been provided in the said rules. It is evident that Shiksha Sarathis were not appointed by following the provisions of Assam Elementary Education Rule 77 because they were not appointed as teachers. Their appointments were in the nature of assistant to single teacher. A separate mode of recruitment was prescribed under this scheme with the different eligibility criteria. Notwithstanding the enactment of the National Council for Teachers Education Act 93 and Right of the Children to Free and Compulsory Education Act, Shiksha Sarathis were appointed, albeit for a period of 11 months, but which has been continued since then. In such a scenario, petitioners certainly cannot claim regularization as teachers because they do not have the qualification of teachers and they were not recruited as teachers. To that extent, the decision of Rumi Gogoi, supra relied upon by Mr. Goswami Lanet Standing Council, would not be applicable to the facts and circumstances of the present case because in Rumi Gogoi Hazarika, education volunteers appointed as Shiksha Mitras under Education Department in EGS Center claim regularization as teachers following upgradation of the EGS Center to lower primary school, which was not accepted by the court, and rightly so, because Shiksha Mitras did not possess the qualification of teachers and they were not recruited by following procedure for recruitment of the teachers. So this aspect was dealt with, my lord. So it's not that this scheme which will be framed, which is required to be framed in terms of the judgment for regularization, no. That is for allowing us to continue till the age of retirement and giving us some medical benefits. Oh, Supreme Court, no? Hmm? Now, would your lordships now kindly come to para 20 of the judgment, which my learned friend has referred just now, my lord, para 20.
Yes,
Mistake or error apparent on the face of the record.
just a minute. Which judgment?
My lord, that 2024 SCC online. That case from Telangana,
Yes,
my
yes.
lord. Para 20.
Para 20.
Yes. Mistake or error apparent on the face of the records would debar the court from acting as an appellate court in disguise by indulging in rehearing. A decision, however erroneous, can never be a factor for review, but can only be corrected in appeal. Such a mistake or error should be self-evident on the face of the record. Error should be grave enough to be identified on a mere cursory look, and an omission so glaring that it requires interference in the form of review. Being a creature of statute, there is absolutely no room for a fresh hearing. The court has got no role to involve itself in the process of adjudication for a second time. Instead, it has to merely examine the existence of an apparent mistake or error. Even when two views are possible, court shall not indulge itself by going into the merits. So therefore, my lord, the scope of review in my humble submission, subject to what your lordships may say, is really circumscribed. If there is an error, it is the province of appeal to correct. At the end of the day, my lord, let us come to the reality that they are not remediless, my lord. Supposing if this review is not entertained also, it's not that state cannot, my lord, address their grievances. So that being the position, my lord, I think it's not a case where lordship would like to interfere with the review application preferred by the state. Lordships will dismiss the review application. That is my answer.
Paragraph 20 is not on the facts, mistake of the facts, mistake of the decision. There is a difference. And that can be that distinction at page, same judgment, if lordships process to paragraph 24, precedent, then first, second, third page. That Parshan Devi's case, paragraph 10, the highlighted. There is a clear distinction between erroneous decision and then error apparent on the face of the record. While the first can be corrected by the higher forum, the latter can only be corrected in exercise of review jurisdiction. So here the factual part is incorrect. So that led to a different conclusion. Had that correct fact being placed at the time of hearing, Lordship, the paragraph 42 would not have come.
Okay, heard Mr. D, anything else?
No,
Heard Mr. D.
there will be no end to it, my lord.
Heard Mr. D. Addition, the learned AGSM. Appearing for the review petitioner, assisted by Mr. NJ Khatane. Also heard Mr. K. N. Chowdhury, learned senior counsel for the respondent, assisted by Mr.
And go.
N.
Gautam.
Gautam. Hearing concluded, judgment reserved. It takes some time. We have got,
No hurry from our
Huh?
side. We are not in a hurry, Lordship.
yes.
Uh,
Thank God for
Mr.
that.
Sakia, can you meet me for 2 minutes?
Yes.
There's
Please.
something I have to
Lord.
inform you.
Lord.
Mr. Chaudhary, not in this case.
And I know.
No,